argumented is for panels to the atom 1, first appeared 164 of 2018, belongs to atom 2 to 4. Now, a batch of 30 first appeal has been filed for a single village number for village cut 2, and order has been delivered on 25th of April for the 6 cases. And here I am providing the list of today's listed with LR number and the area which has been acquired, which along with the
this judgment FA 176 of 2018. Where is the respondent? Yes.
I'm for you.
What do you have to say?
फाइल नहीं तुम्हारा
AGI को बुला लीजिए।
नोट सिलेक्ट आ
कब आएंगे?
सिंपल सर्विस आ रहे थे
कौन है आपके
सिंपल सर्विस
शिव कुमार शर्मा। उनको बोलिए इस जजमेंट को पढ़ेंगे। मिस्टर सुनील कुमार को भी बुला लीजिए क्योंकि वो अपीयर हुए थे इस केस में, आइडेंटिकल केस है। आप इसको देख लीजिए और आप आ जाइए। नहीं, यही नहीं करना है। ये जजमेंट का कॉपी है, इसमें जो पेंसिल दे दीजिए, जो नेसेसरी चेंजेस है करो। या
नहीं आप करके दीजिए।
हाँ, ये है आपके पास, उनको दे दीजिए पढ़ लीजिए। 1 बजे आ जाइए। It is absolutely covered case, same judgments है रजिस्टर, same village का है। ठीक है, Mr. सुनील कुमार was arguing in that matter। अब अपने सीनियर को बोलिए, चाहे तो उनसे बात भी कर देंगे।
For orders notified at item 5, first appeal file number 8903 of 2024.
कितना टाइम चाहिए हमको?
ये जो फाइल का इंटरेस्ट हो गया जो 28 का ये था
कितना टाइम चाहिए?
और 5 बजे का टाइम पे किए थे।
कितना चाहिए था?
28 फरवरी को
तो
28
टाइम
जनवरी
भी एक्सपायर कर दिया।
जी वो वाला ये तो इंटरेस्ट हो गया।
पिटिशनर नहीं है ना आपके लास्ट 4 हफ्ता का टाइम है। फर्स्ट अपील डिस्कस करके क्या
नहीं वो तो कोई पर्पस भी नहीं, फिर सेशन फाइल होगा अननेसेसरी होगा।
unless there are compelling circumstances, दो चीज में केस हम डिसमिस नहीं करते।
जी जी
लिमिटेशन
मेरिट को ज्यादा
ये क्या फायदा?
मेरिट को ज्यादा
सफर आने से एक और केस जनरेट हो जाता है। FA number 8903 of 2024. Nobody appears for the appellant. Counsel for the respondent is present. IA number 1207 of 25 has been filed seeking extension of time for removal of defects. The IA was a prayer was made for granting 4 weeks time. The time has already expired. The time as prayed has already expired. However, the appeal has remained defective. For the ends of justice, time till 13th of June is granted to the appellant to remove the surviving defects. Entry IA post. If the defects are removed within time, post this case on 17th of June.
For admission item 6, contempt civil 755 of 2024.
Who is for the petitioner? or LPA?
LP, no, LP.
SLP. From where do you get this?
LP is preferably CC, Your Lordship.
LP or SLP?
No, Your Lordship.
LPA is pending. LPA is pending, that is admitted, though there is no stay order, but it is on board for hearing. Yesterday also it was listed, so it will again come next week, I think, Thursday.
That's right. Contempt within bracket civil 755 of 2024. It is reported that LPA has been filed against the judgment dated 8/4/2024 passed in WPS number 177 of 2023. LPA का number?
LPA number is, I will just hand it over. It was listed.
LPA number then. Pose this case on
Yes, 504 of 2024. LPA
504 of
2024.
2024.
20.
24, right?
24.
504 of
504 of 2024, correct.
Pose. Relax.
There was some legs in code 16, no?
It's good that you know this. पानी पिलाइए नहीं पानी पानी आपको पता है क्या करना चाहिए? कुछ लोगों को ऑनलाइन के लिए बैठा देना चाहिए एकदम चुनिए जहाँ टाइम लेना है छोटा सा सबमिशन करना है तो ये दौड़ने का चक्कर खत्म
Leadership contempt matters are never chota sa matter.
It's not that. For this court, it's a very relaxed matter. कुछ ऐसा नहीं हम तो एक ही चीज चाहते हैं तो ऑर्डर कंप्लाई करिए सेटिस्फाई करिए तीसरा कुछ हम नहीं जानते सिंपल वी शुड कीप इट सिंपल देयर इज नो क्वेश्चन ऑफ एनी issuing any orders which are otherwise not. I don't have that capability. I'll never do it. कभी गलती से हो जाए तो बात अलग है. Pose this case on 4th of July or after disposal of the appropriate LPA, whichever is it. Covered है? सेम ऑर्डर करते सेम एविडेंस से कोई फर्क नहीं है वो हम उनको बोले हैं देखिए उनको हाँ सारा चीज आप मेंशन कर देंगे कौन सा एरिया है क्या है ये आपका काम है
हाँ ये कर दिया
दिखाइए इसमें कॉम्पनसेशन आपने 15,000 से ही क्लेम किया था एवरी पीस एग्जिबिट नंबर तो सब सेम है
एवरी पीस तो बैच कैसे
The order is also common.
सेम
Same order. देखिए, FA number 164 of 2018 with other analogous cases. The counsel for the applicant has submitted that the case arises out of the common judgment passed in numerous land acquisition cases and arising out of the same judgment, a batch of first appeal has already been disposed of by this court, by which the compensation in connection with the land has been enhanced from rupees 3,000 per decimal has increased from as the flat rate of rupees 3,000 per district to flat rate of rupees 7,000 per district. The learned counsel submits that this appeal be disposed of in the same terms. The learned counsel for the respondent has no objection to the plea agreement and has submitted that the case is squarely covered by FA number 176 of it. Disposed of in the same terms.
Permission item 7 contempt civil 158 of 2025.
उसका ऑपरेटिंग पोर्शन में देखिएगा पार्टली अलाउड है कि क्या है एकदम उसी तरह से आपका प्रोग्रेस भी वैसे ही जाना चाहिए. Yes. This is correct.
Direction was to pass a reasoned order.
Yes.
Reasoned
That-
order has not been passed.
Your Lordship, a show cause has been filed in the case. The claim of the petitioner was rejected.
So, what do you mean reason order is not?
Reasoned order has not.
You can challenge this, right?
नहीं, reasoned order this case के लिए फाइल हुआ है Lordship. ये दूसरे
I-
केस के बारे में दिखाकर बता रहे हैं.
ये जो इस रीजन ऑर्डर में जो बातें लिखी हैं आपके केस से रिलेटेड नहीं है.
तो उसमें Lordship 7th पेमेंट फिक्सेशन भी था, ACP MACP का था, तो some part is different.
ये रिट का नंबर क्या है?
Lordship,
2831, right? Corresponding writ petition is 2831 of 20. You don't have the copy of the brief.
Your Lordship, just
आपको क्या लगता है?
Lordship 2381 of 20.
रीजन ऑर्डर में कौन सा केस नंबर लिखा है?
Your Lordship, that is a general reason order. It
आपके
has been,
जनरल रीजन ऑर्डर से आपका ये कोई जनरल ऑर्डर नहीं है कि
Your
जनरल
Lordship, regarding the scheme it was said, and the
We
scheme,
are not bothered about it. You have to pass a specific order in connection with this case number.
Your Lordship, praying for 2 weeks, we will be passing 4 weeks.
किस
Maybe.
तरह का compliance है?
Your Lordship,
We do not know what is this. You can say in your reasoned order that this happened in another case or whatever.
Your Lordship, we will be filing that show.
कौन ये शोभा स्वाति? Who is that great man?
Your Lordship, Director.
Director of?
Higher Secondary.
Ask him to join online. Ask him to join online at 2:15. बुला नहीं रहे कोर्ट में, ऑनलाइन ज्वाइन करने बोलिए क्योंकि जो चीज़ आपको बोल रहे हैं वो उनको समझ में नहीं आने वाला. नेक्स्ट केस.
Item 8 contempt civil 316 of 2025.
Yes.
Order has not been complied. What happened, Lord? Regarding payment of 7th pay revision, Your Lordship passed the order Lord on 15/5/2015, page number 20. Page number 20 of it. Only the schedule 90. Direction was given to pay the 7th pay revision because the government has already notified to comply the order. Your Lordship directed to comply the order with 6 month time was given by Your Lordship. 6 months. It was over in November. Then, my Lord, the government has given the affidavit in this case. कई अरब रुपया इनको यूनिवर्सिटी को दे दिया, सैकड़ों अरब रुपया दे दिया यूनिवर्सिटी को पेमेंट करने के लिए. यूनिवर्सिटी इज नॉट पेइंग. इस तरह के जितने केसेस हैं, 15-20 केसेस हैं, किसी में यूनिवर्सिटी जवाब भी नहीं दे रहा है, पेमेंट तो दूर की बात है. जवाब देंगे तो पेमेंट करना होगा. अब उधर एक बात और, एक चीज और, उसने ये प्ली लिया है यहाँ पर लास्ट ओकेजन. मैंने कहा कि कॉलेज ऑलरेडी डिमांड कर चुका है, तो इन्होंने इनकार किया कि नहीं, कॉलेज डिमांड नहीं किया. कॉलेज ने रिप्लाई दिया है कि हमने नवंबर 2024 में ही डिमांड किया है, लेकिन ये यूनिवर्सिटी बिल्कुल ही किसी की बात नहीं सुनती है. आप सफिशिएंट मनी जो है रख के अब क्या करती है हमको समझ में नहीं आता है कि फिक्स डिपॉजिट में रहता है कि कहाँ रहता
समझ में नहीं आ रहा. आपका वेट कर रहे हैं. वेट कर रहे हैं इनका. Who's for the university?
college.
University has filed show cause?
University is not a single case they have filed the show cause. There are 15-20 cases हैं. Comply ही नहीं करते बिल्कुल. Show cause ही नहीं देते.
कौन है OP number?
OP number.
Single edition. Okay, number 3.
इन्होंने एक show cause किसने फाइल किया है इसमें?
ये
Show cause सरकार ने दिया है और कहीं सिटी कॉलेज ने दिया है.
है compliance report validation.
Saying what?
तो एक तो पुलिस वाले ने सिर्फ
सर
सिंपल.
प्लीज आप थोड़ा सा एक पेशेंस रखिए ना. आपको सुन लिए ना.
Let us be
अब
direct.
सोच रहे हैं कि करना क्या है. ऐसा नहीं हो कि उनका शो कॉज रिकॉर्ड पे हो और उनको चला जाए, क्योंकि सारा चीज तो आपको पढ़ के भी नहीं आता. हाँ, सुनने दीजिए.
State were directed to serve the notice to the opposite party number 4, Kareem City College. We have done so and we have filed a compliance.
So that part is over. उसके अलावा
And one show cause has been filed stating that we have received a fund of rupees.
where is that show cause?
Show cause is 25,320. It's in paragraph number 6.
Paragraph 6. Paragraph 6 में क्या है?
That
There
also
is one show cause of OP number 4.
I am.
This college.
Yes, sir, college.
Okay. This is dated 9/4/25.
Yes, sir.
What have you stated there? What is your stand in that show cause?
यूनिवर्सिटी जो हमको 7P के लिए जो लेटर भेजा 9/3/24 को, उसका हम टोटल क्लियरेंस जो 7 CPO है
9/3/24 का
हाँ, ये एनेक्सर 1 मिनट पेज नंबर 10.
पेज नंबर
10
ओके. यूनिवर्सिटी ने आपको क्या चीज के लिए भेजा?
कि पदाधिकारी दिनांक इतना इतना को नियुक्ति 7 CPO के अंतर्गत सातवीं पूर्व वेतनमान पेंशन पारिवारिक पेंशन का लाभ दिनांक इतना से संबंधित उल्लेखित शर्तों के साथ अधिसूचित किया जाता. हमको इन्फॉर्मेशन दिए. उसके बाद हमने टोटल पिटिशनर इंक्लूडिंग अदर एम्प्लॉय का सभी एनेक्सर 2 पेज 14.
What have you done?
यस मैम. 4/10/2024 को हम
सारा भेज दिया.
सारा हम भेज दिए 18 एम्प्लॉय
18.
और उसके बाद फिर रिमाइंडर मिनट हम 18/11/2024 को भी भेज दिए.
ये तो रिमाइंडर नहीं है, सबमिशन ऑफ प्रोविजन पीपीओ
हाँ पीपीओ का सभी हम
भेज दिया. बट दे आर नॉट एक्टिव. द यूनिवर्सिटी इज नॉट एक्टिव. देखिए कंटेंट केस सिविल नंबर 316 of 2025. Counsel for the petitioner and respondent number 1 and 4 are
One,
present. 1, 2 and 4 are present. Counsel for the opposite party number, respondent number, opposite party number 5.
3
Opposite party number 3. No, 3 to Raji University. Opposite party number 4 has submitted that needful has already been done from the side of opposite party number 4, but in spite of that, opposite party number 3 is not releasing the payment, due to which the payment has not been remitted to the petitioners. Counsel for the petitioner has submitted that the order passed by this court has remained uncomplied, and one of the petitioners, and all the petitioners are senior citizens,
Yes.
and two of them are more than 90 years of age, about 90 years of age. it has been submitted that it is only because of OP number 3, the order of this court is not being complied. That issue notice.
Yes, state.
Office is directed to issue notice to opposite party number 3 through the concerned police station, for which requisites be filed by the petitioner as to why a contempt proceedings be not initiated against the opposite party number 3 for willful and deliberate non-compliance of order passed in WPS number 424 of 2023 dated 15/5/2024. The requisites be filed by day after tomorrow. The council, the notice be served in presence of witnesses. Witness के presence में notice serve करना है, ठीक है? Council for the state is directed to seek instructions from the officer in charge of the concerned police station and file affidavit of service. It, opposite party, it is open to the opposite party number 3 to engage an independent counsel to defend himself.
For university hearing for the
क्या instruction है? Order तो हम कर दिए.
Your edition on last year itself, we were instructed that the demand has to come from the college concerned.
They have already sent it. कोई बात नहीं, notice किए हैं, you don't need to worry. आपका appearance order होने के बाद नहीं है.
Subject to question. Stand of the state in para 6 must be narrated to court. They have said that sufficient amount.
एक second. The notice should accompany all the affidavits filed in the present case. आप सारे affidavit notice के साथ.
From daily list for orders at item 1, second appeal 556 of 2004.
So in this case, we have filed an arrears for setting aside the document information. In this case, Your Lordship, appeal number 1, respondent number 4, and respondent number 5 has died in the pendency of the second appeal.
Respondent number.
Respondent number 5, appeal number 1, and respondent number 4.
Then you respondent number
4 and 5.
4 and 5.
And appeal number 1.
And applicant number 1. So,
They have died in the
when did respond number 4 die?
respondent number 18/3/2028.
20? When did he die?
18/3/2028.
28.
8, sorry. 2008.
Respond number 5.
Respondent number 5 had died in the year 14/11/2010.
And respond number 5.
Respondent number 5.
Sorry, applicant number 1.
Applicant number 1 died in 13/11/2010.
This is an admitted second appeal. कौन है आपके सीनियर?
My senior is Mr. Vikesh Kumar Patel. This case is one of our associates.
Second appeal number 556 of 2024. आपका नाम बताइए.
Praveen Shankar.
Mr. Praveen Shankar, advocate actress. However, he is not ready with this. आराम से 2nd January को करेंगे. 2026. चलिए. Second half. आपके अनुसार डेट और टाइम नहीं दे सकते. फाइल पढ़ने का काम आपका है, मेरा नहीं.
Item 2, second appeal 322 of 2016.
जिस केस में जो आदमी फाइल नहीं पढ़ के आएगा उसका 2nd जनवरी 2026 का डेट फिक्स हो जाएगा. ऑफिस नोट पढ़ना अब पिटीशन पढ़ना आपका प्राइमरी काम है। बताइए क्या बोलना है?
On the last day ordinary process, through ordinary process, I have sent the notice to the office owner.
आगे ऑफिस नोट क्या है?
I have not seen it.
Also further Abhinam Samit sir, नाम बताइए मिस्टर सुरेश कुमार।
Yes, ma'am.
Samit sir, he has not gone through the office note. Same date. हम लोग को क्या चाहता है? आपका सब्स्टिट्यूशन होते जाएगा।
नोटिस तो मैंने भेज दिया।
ऑफिस नोट कौन पढ़ेगा? चलिए नेक्स्ट केस करो।
Item 3, WPC
आराम से
04.05 of 2016.
नोटिस सर
आराम से।
भेज दिया।
कुछ नहीं, हम नहीं जानते। ऑफिस नोट आप नहीं पढ़े हैं, हम यहाँ पे ऑफिस नोट पढ़ के रेडी नहीं हो सकते। चलिए कहाँ है ये? Who is appearing? Yes, what is it?
आइए तो डिलीटिंग द नेम ऑफ द पिटिशनर नंबर 1 लॉर्डशिप, लेकिन इसमें डेथ सर्टिफिकेट हम लोग को जो मिलने थे वो अभी तक मुझे नहीं मिला। 13 जो रिस्पोंडेंट नंबर 13 है वो पिटिशनर नंबर 1 का सन है। क्योंकि ये अपोजिट पार्टी से ये कमेटी को रजिस्टर्ड करवाए, उनके कैशियर का वो सर्टिफिकेट मुझे देने से भी इनकार कर रहा है, डिनाई कर रहा है कि मेरे पास नहीं है। तो हम तो ऑथराइज पर्सन है नहीं पिटिशनर 2-3 इनका सर्टिफिकेट लेगा। तो आई एम नोइंग दैट वो डेथ कर चुकी है, बरियल सर्टिफिकेट
अपील नंबर 3 का डेट हो गया है।
1 हाँ 3 लॉर्डशिप पिटिशनर नंबर
अपील नंबर अच्छा रीट का
पिटिशनर नंबर
3 has accepted, right? आपका ये मैटर सुना है ना?
2-3 बार टाइम लिया गया है।
आप कौन है रेस्पोंडेंट नंबर 13 की तरफ से?
Respondent number 13 is the son of petition number 3.
Who is appearing for respondent number 13? Is anybody appearing? Dismissed, ये तो DFT हो गया उनके अगेंस्ट में। ये रेस्पोंडेंट में कैशियर है।
कैशियर कमेटी जिसमें जो
कमेटी कैशियर कैसे कोई नाम तो होगा ना?
Yes,
कैशियर
इमामुद्दीन अंसारी।
मदीना मस्जिद
नेम ये इमामुद्दीन अंसारी उसमें मेंशन किया हुआ है।
लेंगे इमामुद्दीन अंसारी। तो इसका तो हम कुछ कर नहीं सकते ना, फाइल करना पड़ेगा।
अब क्या है कि हम पिटिशनर नंबर 1-2 है मेंबर है उस कमेटी का, और ये मैडम जो डेथ की डिजीज मैडम ये रजिस्टर्ड लैंड दी थी मस्जिद बनाने के लिए, और उसमें मस्जिद बन के चलती आ रही है। अपोजिट पार्टी रिस्पोंडेंट नंबर 11, 12 और 13 ये कमेटी के मेंबर जो रॉन्गली रजिस्टर्ड करवा रही है मस्जिद को अपनी कमेटी के नाम से। इशू यही है, ज़मीन देने वाली मैडम दिस इज पिटिशन नंबर 3। आइए अपने सर्टिफिकेट में मेंशन की थी कि हमने ज़मीन दिया जिस कमेटी को रजिस्टर्ड है पिटिशन नंबर 1 उसके प्रेसिडेंट और सेक्रेटरी। अब ये डेथ कर गया, उसके बेटा चूँकि अपोजिट पार्टी अपोजिट कमेटी से है तो वो सर्टिफिकेट के बारे में कुछ ना बता रहे हैं ना दे रहा। हम ऑथराइज है नहीं सर्टिफिकेट लेने के लिए। पिटिशन नंबर 1-2
कहाँ से मिलेगा सर्टिफिकेट?
डेथ सर्टिफिकेट अंचल से मिलेगा।
सर्कल ऑफिस में
अंचल खिलाड़ी में अंचल ऑफिस से इशू करेगा।
सर्कल ऑफिस
ब्लॉक
करता है
ब्लॉक ऑफिस
ब्लॉक नहीं यहाँ करता है,
ब्लॉक से करेगा, ब्लॉक से करेगा।
Who is for the state? स्टेट को बोलते हैं वेरीफाई करके। स्टेट का काउंसिल नहीं है यहाँ पे, बुला के लाएंगे। Are you there for the state?
So I'm just verifying who is.
Sorry.
I'm just verifying who is the council.
Item 4, second appeal 133 of 2017.
बताइए।
This license is issued to the respondent for tackling pendency of this second appeal lawsuit as per the office import lawsuit. The respondent number already appeared lawsuit. They filed the wakalatnama on 8/3/2023.
In compliance of court's order, notice was issued to propose legal heir or successor of deceased respondent.
Yes, sir.
Yes.
Already they filed the wakalatnama lawsuit on
When? After his death.
Yes, after his death. Earlier we filed also IA lawsuit for submission of legal heir lawsuit. At that time they appeared lawsuit and filed wakalatnama.
They means what?
But respondent number 111 lawsuit.
Respondent number 1 has expired.
Yes, lawsuit. The legal heir of respondent number 11 lawsuit. 1 lawsuit. Sampati Devi, para 4 lawsuit.
Respondent number 11. She is the only legal here.
Only legal.
So respondent number 11 has appeared through wakalat. Fair enough. What about others? Okay, we will accept the notice. Accept this. 1-1 का आइए कौन सा था? Was there any idea?
Lordship, in his presence, Lordship, order for notice was issued, Lordship. It was his duty to inform this honorable Lordship that they already appeared on by filing the Vakaratnama on 3rd March 2023, Lordship.
अगर respondent number 1 कौन से order से इनको notice हुआ?
लॉर्डशिप फर्स्ट नोटिस हुआ था इनका आईए से रेस्पोंडेंट नंबर 1 जो डेथ किए थे आईए इनका पहला आईए था
कौन सा आईए?
आईए 4888 चार लोगों के पर्पस लीगल हेल्थ का नोटिस हुआ था
एक सेकंड 4888
तो असिस्टेंट कोर्ट मिला
हाँ just 4888
ऑर्डर डेटेड है
20/2/2020
ऑर्डर नंबर 6
जो है ना
ऑर्डर नंबर 6 में
पढ़ाता नहीं है तो बोला के लिए फ्रेश स्लिप लगाया 4888
हां ऑर्डर नंबर 6 में
4888 कब का?
आईए इनका है उस पर
4888 2019 में हम लोग फाइल किए थे, which was withdrawn on 20/2/2023 की already हम लोग petition पर आईए फाइल कर चुके थे.
प्रॉपर असिस्टेंट ट्राई टू प्रॉपर असिस्टेंट
How they mislead this number? Database so long.
दोनों जने कोर्ट के बाहर चले जाइए थोड़ा झगड़ा वगड़ा करके आइए उसके बाद
They already appear कर चुके हैं, mislead कर रहे हैं.
भाई यहाँ पे आईए का कॉपी नहीं लगा हुआ है वो अलग कर दिया होगा
हाँ, I number 4956 of 2023.
4956 और 2013
2013.
आपको 2019 का कोई आईए बोलो
इनका आईए है 4888 2000 2019 का इनका आईए है जिसमें प्रपोज
आईए का नंबर
हाँ 4888 आईए नंबर 4888
आईए
2019 इसमें ऑर्डर डेटेड ऑर्डर नंबर 6 ऑर्डर डेटेड 17 सितंबर 2019
कौन सा 17
सितंबर
9
2019
2000 this आईए was for substitution of
सब्स्टिट्यूशन ऑफ
Legal evidence from
नंबर 1
आपसे नहीं पूछ रहे ना आप प्लीज दोनों जने बोलते समझ में नहीं आता बैठ जाइए बताइए रिस्पॉन्ड नंबर 1 का
127 29
127 29
36
36 okay
issue notice the purpose legal yes
okay notice was
then
79 yes okay 79 का order ठीक है नोटिस हो गया उसके बाद
after notice I am appearing the purpose legal yes
ऑफ किसकी तरफ से सबकी तरफ से अपील करते हैं
हाँ लीगल है जो प्रपोज लीगल है नोटिस हुआ तो उसके तरफ से अपील हो गया
कौन सा सारे 127 29 36 सबका
ये 1127 129 1229
पूरी नहीं पता इनके पास कौन सा वकालत है
फोटोकॉपी रखे हुए हैं पार्टी
किनकी तरफ से अपील कर रहे हैं आप
ये ऑफिस रिपोर्ट पे भी आया हुआ लास्ट ऑफिस रिपोर्ट डेटेड
रेस्पोंडेंट नंबर 1 का एक ही लीगल हियर है
उनका भी है
ठीक है रेस्पोंडेंट नंबर 1 का कहानी खत्म
उसी के सिपाही
अपना हमारा
27 का कितना लीगल हियर
हाँ 27 का वो ऑलरेडी हम अपील कर चुके हैं
कितना लीगल हियर है पूछ रहे हैं अपील कर चुके हाउ मेनी ओनली वन और मोर देन वन 27 का अभी 27 का अच्छा ठीक है 27 का भी वकालतनामा फाइल हो गया 29 का 1 to 4 इनका भी वकालतनामा फाइल हो गया 36 का
भी वकालत प्रपोज लीगल
36 1 का नहीं फाइल हुआ 36 1 कौन है
1 का भी पर माय
who is 36 1
2 and 3 का
36(1) कौन है?
गोमा देवी।
36(1) का वकालतनामा नहीं फाइल हुआ है, बताइए, नाम बताइए। 36(1) कौन है आपके पिटीशन में? बताइए, आपने फाइल किया था ना सब्स्टिट्यूशन?
हाँ आइए
आइए, 36(1) कौन है जिसका वकालतनामा नहीं फाइल हुआ है? Who is 36(1)? आईए का कॉपी नहीं है 2019 का आपके पास? उसी में देखिए। का आईए विड्रॉ कर लिए थे क्या?
हाँ वही हम इसीलिए बता रहे हैं।
ये विड्रॉ कर
जरा हमारा सुन लीजिए इसलिए।
दो बाद में एक और हम लोग आईए फाइल किए थे, तो हम लोग सेम चीज के लिए 2 आईए फाइल किए। इसलिए फर्स्ट वाला हम विड्रॉ कर दिए और सेकंड वाला में इसलिए अवेट कर दिया जबकि ऑलरेडी अपेयर कर चुके थे। इनका ड्यूटी था कोर्ट कंफर्म करने के लिए रिस्पोंडर 1
दूसरे का ड्यूटी गिनाना बंद करिए, अपना ड्यूटी पे ध्यान।
नहीं जब वकालत
2019 में आपको पता था ना कि डेथ हो गया है?
हमको शुरू से जब हम आफ्टर फाइलिंग ऑफ दिस मेमो ऑफ अपील लॉ से इट वाज ड्यूटी, इनका ड्यूटी था कि इन्फॉर्म करने। जजमेंट वाज पास अगेंस्ट अ डेड पर्सन ऑल्सो। हम लोग यहाँ सेकंड अपील में हम लोग जब नोटिस हुआ तब हम लोग के नॉलेज में आया कि उसका डेथ हो गया, उसका हम लोग आईए फाइल किए सब्स्टिट्यूशन के लिए।
तो ये विड्रॉ क्यों कर दिया?
क्योंकि दो आईए गलती से फाइल हो जाते हैं, उसी के लिए मोहन
पुराना वाला विड्रॉ
आप पुराना वाला को विड्रॉ करें।
क्यों? पुराना वाला रहेगा ना, नया वाला विड्रॉ होगा। क्यों विड्रॉ किया पुराना? 2 केस फाइल हो जाएगा तो पुराना वाला सर्वाइव करेगा, नया वाला सर्वाइव नहीं करेगा। कोई खास कारण था विड्रॉ करने का?
विड्रॉ करेंगे क्योंकि अवेट इनका जो सबमिशन था कि सेकंड अपील हैज बीन अवेटेड अगेंस्ट द लीगल ऑफ रिस्पोंडेंट सो प्रेयर ऑफ द
ओनली रिस्पोंडेंट नंबर 1 की बाकी सब
ओनली रिस्पोंडेंट नंबर 1 लॉस नोटिस इशू हुआ था लिमिटेशन बैठ अवेट करेगा तो फिर पूरे सेकंड अपील नॉट अवेट अगेंस्ट ऑल द पार्टीज लॉस अवेट क्योंकि क्या था रिस्पोंडेंट नंबर 1 पर करता हम लोग इस इंफॉर्मेशन दिए कि इनको ये अपेयर सेकंड बार आईए में इनको मालूम था ये अपेयर कर चुके थे। सेकंड आईए जो हम लोग फाइल किए थे
36 रोमन 1 कौन है, नाम बताइए। Have you filed वकालतनामा on behalf of 36 Roman 1?
Only 2 and 3.
नहीं वन क्लेम फाइल कर चुके हैं। इनका नाम है करके लक्ष्मण
साधना में तो 1
उसको वेरीफाई करना पड़ेगा, क्लाइंट से पूछना पड़ेगा।
क्या हस्बैंड में 36 36(1) के हस्बैंड जो डेथ हो गया उनका हस्बैंड और बाकी लोग बच्चे हैं। थर्टी सिक्स वन का वकालतनामा क्यों नहीं फाइल हुआ? आप तो सेम फैमिली मेंबर है।
मंगा हो जाता है इसलिए हुआ उसमें मैडम लोग फिर जो 4 डिसीज पर्सन सब्स्टिट्यूशन के लिए फाइल किए और कोई दिक्कत है तो नोटिस होगा।
देखिए आपको एक चीज बता दूं, आपको जितना अपोज करना है ना एफिडेविट फाइल करें।
हम अपोज नहीं कर रहे,
अपोज नहीं कर
हम कभी इसको अपोजिट की बात नहीं, इसको असिस्ट द कोर्ट जो आईए विड्रॉल हो गया उसके बाद फ्रेश सब्स्टिट्यूशन फाइल हुआ, उसमें सिर्फ 2 ही लोगों का सब्स्टिट्यूशन फाइल हुआ, 2 का अभी तक फाइल नहीं हुआ।
इसी का अभी तक फाइल
नहीं, इसी
किसका फाइल नहीं
कोर्ट का असिस्ट में ये पता करना
किसका फाइल नहीं?
इस पर माय रिकॉर्ड रेस्पोंडेंट 29 और 36
पुराना तो फिर 29
फर्स्ट में 4 का नोटिस हुआ,
नोटिस भेजने का क्या बात?
फर्स्ट टाइम नोटिस हुआ उसको उस आईए को लोग विड्रॉ कर लिए, अपीलेंट हैज विड्रॉ।
डू यू गेट दैट? व्हाट इज द सेकंड आईए नंबर?
हां सेकंड आईए
My second IE is IE number 4956.
4956
56
of
2023.
उसमें किसका सब्स्टिट्यूशन है?
1 का एंड 27 का फिर नया उसमें न्यू डिसीज पर्सन रेस्पोंडेंट अपील नंबर 20 का भी है
127 and 20 का, ठीक है?
और रेस्पोंडेंट 10 का भी उसमें आ गया है।
रेस्पॉन्ड नंबर 10 का भी
एक
उसमें।
न्यू बात में फिर की उनका
आप आपको बताइए 29 and 36 का कौन सा सब्स्टिट्यूट है? 3 जनरेशन बीत जाएगा आपका सेकंड अपील डिसाइड करने में। कुछ नहीं करना।
2936 का फंक्शन है
10 मिनट से क्या करना है? जब फाइल नहीं देख रहे हैं तो क्यों बहस करना शुरू कर?
नहीं फाइल देख लीजिए 2936 के बारे में इसके बारे में इन्फॉर्मेशन तो नहीं है ऑर्डर दे दो
The learned counsel for the applicant is present. The learned counsel for the respondents, some of the respondents, has submitted that IA number 488 of 2019 was filed seeking substitution of respondent number 1, 27, 29 and 36. But the same was withdrawn and fresh and another interlocutory application was filed, being IA number 4956 of 2023, but it was for substitution of respondent number 1, 27, 20 and 10, and consequently there is no surviving petition for substitution of respondent number 29 and 36, correct? सुने आप? Counsel for the appellant has submitted that by mistake 2 petition for substitution was filed and therefore the earlier IA being IA number 4888 of 2019 was withdrawn. However, he prays for time to verify the records as to whether any substitution petition with respect to respondent number 29 and 36 is pending. ठीक है? कब रखना? देख रहे हैं ना हर बार सब्स्टिट्यूशन में 2-3 लोग मर जा रहे हैं। ऐसा नहीं कि डीएफडी हो जाए, रेस्टोर नहीं करवा पाइएगा। अगर डीएफडी हो गया ना ये केस आप रेस्टोर नहीं करवा पाइएगा।
आइए जैसे
ना मेरे लाइफ टाइम में ना अपने लाइफ टाइम में।
रिस्पोंडेंट नंबर 1 के हम सेम सबमिशन करेंगे ऑलरेडी जब अपडेट
आप
करके
पहले इसको ठीक करिए।
पिछले बार में भी जब नोटिस हो रहा था इनको इन्फॉर्म करना
जब
चाहिए
तक फॉर्मल सब्स्टिट्यूशन पिटीशन के बाद सब्स्टिट्यूशन नहीं होगा, सिर्फ अपीयर करने से नहीं होगा ना, देयर हैज टू बी अ प्रॉपर सब्स्टिट्यूशन फर्स्ट। अगर आपने 4888 ऑफ 2019 को गलती से विथड्रॉ कर दिया है तो उसका भी आप पिटीशन फॉर रिकॉल फाइल करके किया जा सकता है, ऐसा नहीं है, बट यू हैव टू टेक सम स्टेप। जब तक आपका प्रॉपर पिटीशन से सब्स्टिट्यूशन नहीं होगा, merely because somebody has filed वकालतनामा, we will not take that person on. समझ गए? कब रख दें?
नेक्स्ट
Next week. Next week. Next week. There is a proper procedure in civil litigation. ऐसे नहीं होता। उनको दे दीजिए रिकॉर्ड, आराम से देख लीजिए, और भी जो रिकॉर्ड है वो भी इनको दे दीजिए।
Item 5, second appeal 396 of 2018.
Respondent number 3 has died. IA petition.
हाँ, ये
Substitution
for
of the legal aid of respondent.
respondent number 3. Respondent number 3 is under caveat.
And for respondent number 1 and also.
Only for respondent number 1. Respondent number 2 undelivered governance. Is it within time?
No, sir. Delay is about 1 year.
This is second appeal admitted. Second appeal?
Yes, you
It's
बाकी को सर्व हो चुका है? Service of respond number 4 to 6 validly served. It already served है. 1 तो already वकालतनामा से आपने 2 and 3. 2 का insufficient address.
Based on standard.
3x. Notice 2 को सर्व करना जरूरी है. Fresh उनका fresh current and fresh address है उनका. चाहिए. Respond number 2 कौन है?
Based on number 2 के लिए trace notice फाइल की है. Recently.
कब है? आपने समय के बाद फाइल की है, इसीलिए डिस्पैच नहीं. फिर चला गया लास्ट में. यही है इसका insufficient address. ऐसे नंबर 396 of 2018. The notice could not be delivered on respondent number 2 on account of insufficient address. Counsel for the petitioner, appellant prays for and is granted time till 9th of May. To take fresh steps for service of notice upon respondent number 2 at present and correct address. Present, current and full address. The requisites under ordinary process and speed post be filed by 9. दोनों से हो जाएगा, ठीक है? ये तो मेन अपील में जाएगा, सेकेंड अपील में जाएगा. Post this case on 20th of June, awaiting service report, office to track speed posting.
Item 6, second appeal 400 of 2019.
Notice has been issued to the press notice on number 10C 23 to 24. As per office note number 15/2025, respondent number 10 received self and respondent number 23 received by father-in-law and acknowledged the noticee by phone number. And 24 returned unserved and noticee not found at given address.
Take steps, fresh steps.
Press present and press.
Essay number 400 of 2019. Counsel for the appellant has submitted that in view of office note, the notice upon respondent number 10C and 23 be accepted as validly served. Considering the office note, the notice upon the same respondents is accepted as valid. So far as respondent number 24 is concerned, the counsel for the appellant prays for and is granted time till next Friday.
No.
Till next Friday, that is 9th of May, to take fresh steps for service of notice under ordinary process and speed post. For which requisites be filed by 9th May. अभी कौन सा डेट थी? 13th May. अभी previous case में 20 June. Post on 28th June, awaiting service. Office to tax speed post.
Item 7, CIP 717 of 2019.
last order is concerned, we published the notice in the newspaper and I have given the supplementary affidavit to that effect. So for the OP 17 is concerned. So it is valid this supplement. IN number 13-207-24. This may be allowed.
I allowed कि आपकी substituted service हो ही गया, मतलब allowed तो हो ही चुका है पहले से. Counsel for the appellant has submitted that notice, substituted service of notice through newspaper publication to opposite party number 17 is complete. The newspaper publication has been annexed with the supplementary affidavit.
Right on. Supplementary affidavit has no charge of this.
No charge.
I have filed on.
Notice upon respond number 17 is taken as validly, sir. आगे बताइए.
आगे इसमें यही है वो एक वकालतनामा 7 वकालतनामा उन्होंने ने फाइल किया था जिसके लिए वो आए पिटीशन डाले थे 2967 फ्लैग उनका फ्लैग जे में फ्लैग जे में है उनको फ्लैग जे में गलत लिखा गया है 2697 लिखा गया इट शुड बी 2967 फ्लैग में गलत लिखा
2967 ये क्या चीज है ये?
इसमें उन्होंने कहा था कि क्यों मैंने 7 वकालतनामा अपोजिट पार्टी के नाम से दिए थे उसका खंडन हमने इसी पिटीशन में इस सप्लीमेंट्री एफिडेविट में हमने दिया है पैराग्राफ 3 में उनका जो पैराग्राफ 3 का आंसर है वो मैंने पैराग्राफ 3 में ही दिया है सप्लीमेंट्री.
This has been filed pursuant to order dated 29/11/24. Correct? अब 29/11/24 का क्या ऑर्डर है? कल्पना झा and कल्पना देवी are one and the same person.
हमने उसको लिखा पैराग्राफ 3 में एक उनका जो ये है एक्सप्लेनेशन है
कौन सा आइए फाइल किए आइए नंबर बताइए.
हम आए नहीं थे जो सप्लीमेंट्री एफिडेविट में उसका जवाब दिया
2967 by 2967
67 that is filed by opposite party.
क्या है इसमें आपका एफिडेविट है?
नहीं हाँ उनका फ्रॉम द स्टेट प्राइवेट रेस्पोंडेंट ए opposite party. Paragraph 12
They have given the details.
क्यों उन्होंने क्योंकि he has filed some वकालतनामा on behalf of some persons वकालतनामा who were not party in the
That's
law.
तो क्या लिखते हैं ये?
उसमें लिखे हैं पैराग्राफ 3 में देखा जाए उनका पेज 3 उनका पिटीशन जो 2967 Ombudsman Chandra Jha is the original defendant in the suit but it appears that the petitioners in the restoration application has been inadvertently mentioned the name of Mrityunjay Chandra Jha. तो हमारा जो सेकेंड अपील का ये है उसी का हम जवाब दिए हैं हर एक 1 2 3 4 जो लिखे हैं सबका जवाब हमारे यहाँ है जिसमें हम डिनाई किए हैं लेकिन एक में हम एक्सेप्ट किए हैं मेरा भी जो सप्लीमेंट्री एफिडेविट है उसका 3 का 1 2 3 सिलसिलेवार जवाब
ये सब्स्टिट्यूटेड पब्लिकेशन के साथ आप दूसरा चीज पिटीशन का जवाब मिक्स कर दोगे गलत है ना
क्योंकि ये
आइए जवाब फाइल कर रहे हैं तो आइए का जवाब आपको आइए का अलग से जवाब देना चाहिए
उसका सप्लीमेंट्री देंगे ना तो एक सप्लीमेंट्री
आइए का रिप्लाई बोल के ना देंगे
हाँ
सप्लीमेंट्री एफिडेविट का क्या मतलब
हाँ इसमें हमने लिखा है कि
हाँ क्या है
यही सप्लीमेंट्री एफिडेविट में हमने उसको
पढ़ी क्या लिखा
हाँ पेज 2 का 3-1 में देखा जाए
Who is opposite party number 2? क्या नाम है उनका? Who is opposite party number 2? What is the name? Opposite party number 27.
27.
कौन है? 27.
Don't see.
जिनके बारे में इतना कहानी.
Opposite party shown by opposite party number 27. 27 ने ये आय पिटिशन किया.
हाँ.
Ramkinkar Jha has framed a query of the court for filing Okalsnama on behalf of 7 opposite parties, namely Ombu Chandra Jha, Rahul Kumar Jha, Balika Devya, Chutu Devya, Porimal Chandra Jha, Haradhan Chandra Jha, and Montos Kumar Jha, who are not party in the CMP. Is replied in the following way. The memo of second appeal number 280/2004, for which the restoration petitions have been filed and in consequence thereupon, the present CMP number 717/2019 has been filed. There is no opposite party name like Ombu Chandra Jha, which is arising out of suit and title appeal. Rather, Mrityunjay Chandra Jha is the only party who is opposite party number 18 in the present CMP. Hence, such Okalsnama filed is invalid. If Mrityunjay Chandra Jha is also named as Ombu Chandra Jha, then proper step for alias name should have been mentioned in the Okalsnama. And here at this stage, the cause title cannot be modified. क्योंकि हमारा जो 280 में था उसके अनुसार ही हम करके आए. That there are two Santosh Kumar Jha, the second के बारे में बोल रहे हैं. Two Santosh Kumar Jha as opposite party. One is at serial number 24, who is the son of late Sampurna Chandra Jha, and another is at serial number 38, is the son of late Anil Chandra Jha. The replying opposite party has to clarify who died, serial number 24 or serial number 38, and who are the legal heirs with details of their address. That similar is the case with Balika Devya, as to whose widow she is, of serial number 24 or serial number 38. That OP number 24.
Private party is not appearing today. देखिए, IA number 29967 of 25 in CLP number 717 of 2019. Part तो लिखा दिए ना, substituted service. The counsel for the appellant has submitted that in response to the interrogatory application, filed by the opposite parties, objection has been raised in the supplementary affidavit dated 19/3/2025. सर्व नहीं किए हैं आपको, सर्व नहीं किए हैं, इसका कॉपी नहीं दिया है प्राइवेट रेस्पोंडेंट को. However, it appears that the copy of the supplementary affidavit has not been served upon the counsel for the private respondent. Counsel for the appellant is directed to serve copy of the supplementary affidavit upon the counsel for the private respondent during the course of the hearing. ये किया है सर? दे रहे हैं, मतलब हमारा 10 मिनट बर्बाद करके क्या मतलब है?
स्टेट को दिए थे, हमको लगा
बहुत अच्छा किए थे, स्टेट को दिए थे. क्या किस तरह का लिटिगेशन करते हैं? डिसमिस फॉर डिफॉल्ट है, रेस्टोरेशन का रेस्टोरेशन चल रहा है और 3 जनरेशन मर चुका है. क्या कर रहे हैं? क्यों कर रहे हैं ऐसा? Why are you doing this to the litigant? कॉपी सर्व करने के लिए क्या लिटिगेंट आएगा यहाँ पर? Why? जो चीज नहीं संभाल सकते हैं ना, उसको लेना नहीं चाहिए. जब भी ये केस टेकअप होता है, आपका यही कहानी चलता है. सर्व भी नहीं करिएगा आप आधा सही. नहीं थे तो आज हम अलाउ कर देते, कुछ कर देते ऑर्डर.
इसको next
नेक्स्ट में अगला साल रख देते हैं, 2-4 लोग और मर जाएंगे तब तक। यही तो चल रहा है आपका केस, हर डेट में देखो ये मर जाता है। Who is responsible for this? System is not responsible, councils are responsible. Post on 13th June. थोड़ा रहम करिए, लिटिगेट करिए।
Item 8, second appeal table 2 of 2020.
Yes, second appeal.
just today I received the order number 2, 3, 4, 7, 1, 2, 3, 4, 7, 8, 9, 10, 11, 12, 13.
कौन बच?
बच गए 5, 6 and 14. 5 का जो as per information information 5 break कर देंगे।
Should I record?
हमको information जो मिला ये
आप ही का information record करें।
रिकॉर्ड कर सकते हैं क्योंकि उनके बच्चों का जो है वकालतनामा आया तो हम बोले जब तक ये पार्टी इंप्लीड नहीं होगी तो हम कैसे कर सकते उसको नहीं कर सकते।
उनके बच्चों का वकालतनामा आया है,
आया
आप आपके पास डिटेल है?
साइन करता है इसीलिए हम ये सबमिट कर रहे हैं।
तो आप जो रिस्पॉन्डेंट नंबर 5 कर देते हैं ना,
जी यस
तो आप एक एफिडेविट फाइल कर दीजिए, कौन रिस्पॉन्डेंट नंबर 5 कर देते हैं, बच्चों का नाम दे दीजिए, है ना? दैट इज बेटर। नहीं तो अननेसेसरी ये केस में
नहीं
6 and 14 का क्या सिचुएशन?
6 and 14 के ऑप्शन नहीं मिला।
Six received by 7. 614 has been validated. Serve हो चुका है, ठीक है। ऐसे नंबर 5 का वैलिडिटी सर। ऐसे नंबर 52 of 2020. Notices were issued to respondent number 134628. Notice has been served upon respondent number 13467 and 8, which has been received by them. And as per order dated 25/3/2025, it was indicated that notice has been validly served upon respondent number 2, 11, 12, 13, 5, 9, 10 and 14. The learned counsel for the respondents appearing on behalf of
Respondent number 1, 2, 3, 4, 7, 8, 9, 10, 11, 12,
1, 2, 3, 4,
7, 8, 9, 10,
7, 8, 9, 10,
11, 12, 13.
11, 12, 13. Respondent number 1 to 4,
7 to 13.
7 to 13 has submitted that respondent number 5 has expired. He undertakes to file an affidavit before this court, bringing on record the date of death of respondent number 5 and the names of legal heirs and successors of respondent number 5. ठीक है? In view of the office note, the service is complete. The counsel for the respondent shall do the needful with respect to respondent number 5, so that appropriate steps may be taken by them. कितना time चाहिए?
Subject to
Post on 13th. उन लोग का वकालतनामा के साथ ही फाइल करें।
हम साथ में फाइल
अगर डेथ सर्टिफिकेट मिला हो तो फाइल करें।
Item 9, second appeal 203 of 2022.
Notice was issued on 25/3/2025. Fresh steps of notice was served. In compliance thereof, on 29/4/2025, wakalatnama has been filed on behalf of the respondents.
कौन-कौन छूट गए?
Should there be service report had not come regarding 4, 7, 9, 11, 12, 15, 18, 19, 23, 26 to 30, 37 to 39 and 40.
That's it. Now you see, however, execution of respondent number 17, 22, 24 and 41 does not tally with the name in the memo. ऐसा क्या करना?
There are some name का signature हम लोग थोड़ा दूसरे तरह से करते हैं, जैसे उसी से वो ऑफिस में पॉइंट आउट किया।
ज़्यादा ही फर्क है क्या? Other descriptions are okay.
Other descriptions are okay. Name is, for example, number 17 Kamal Mahto. He has died signed as Kurla Mahto.
नेम आप ठीक से लिखे हैं ना?
नेम जो डिक्री में एप्लेट कोर्ट के डिक्री में जो नाम था वही नाम मेमो में,
तो बाकी डिटेल आप ठीक से लिखे?
बाकी डिटेल जो एज पर द डिक्री ही है।
Essay number 203 of 2022. The learned counsel for the appellant has submitted that office has pointed out that so far as wakalatnama of respondent number 17, 22, 24 and 41 are concerned, the execution does not tally with the name in the memo. He submits that the state persons have signed in their own manner, but the description in the wakalatnama is correct. It submits that such office defect may be considering the submissions, the office defect in connection with wakalatnama of respondent number 17, 22, 24 and 41 is ignored for the present. Posed this case on 13th of June awaiting service report of some of the applicants, so some of the respondents. Office to send reminder for service. Already processed हो गया था.
Automatic
Item K, second appeal 267 of 2023.
There is 27 days delay. Why is there your loss?
IE number 3620 of 2023. The Delhi Council for the applicant has submitted that. The second appeal has been filed with delay of 27 days. Issue notice to the respondents through ordinary process for which requisites be in the limitation matter for which requisites be filed by next Friday. Post this case on 20th of June awaiting service.
Item 11, first appeal 209 of 2024.
Ms. Appellant, you are appearing for whom?
Ladyship, I am appearing for respondent number 1 and 2.
What about others?
Because 3 to 5, they are
They have refused.
they have refused to come on my behalf. And other respondents, they haven't appeared that yet, but perhaps the notice have been served upon them. And as far as respondent number 2 to 5 is concerned, they were directed to file a fresh requisition.
They were directed to file fresh requisite, but they have filed it after the time. FA number 209 of 2020. As per office note, the requisites in terms of order dated 12/2/2025 for service of notice upon respondent number 3 to 5 has been filed after the lapse of time granted by this court. Let notice be issued. Let notices which has been filed be issued to the respondent number 3 to 5, fixing the date for appearance on 20th of June.
Item 12, first appeal 221 of 2024.
Fixing the date of appearance on 20th of June, post on 26th. Yes, sir. Yes.
These are in this case, notice to all the respondents have been served, except respondent number 7. Lordship's order dated 15/1/2025, but we were directed to take steps for substitute service of notice upon the respondent number 7 minutes. Because they have prepared the application for filing the substitute service of notice upon respondent number 7. But server the applicant number 1 being old age person, he is not able to come to Ranchi. Now he has given power of attorney to his son. So he will be traveling to Ranchi because he will be paying for a week time. So that the application may be filed.
FA number 221 of 2024. Counsel for the applicant pays for and is granted time to 13th of June to take steps in terms of order dated 15/1/25. Post on 20th June.
Public.
Also, case item 3, the UPC 4475 of 2016.
Is the counsel for the state appearing? There is a problem. So it is the counsel. The petition number 3 has expired. And respondent number 13 is the legal year of petition number 3. But the case has been dismissed as against them. So he is unable to get hold of the death certificate of petition number 3. So you seek instructions and file an affidavit. If not the death certificate, just confirm about the death and file an affidavit. The UPC number 4475 of 2016. Counsel for the parties are present. Counsel for the appellant has submitted that petition number 3 has expired and respondent number 13, namely Imamuddin Ansari, son of late Bahadur Ali, a resident of village Lapra, POPS, Maklaxidan, district Ranchi, is the legal heir, but the case has been dismissed against respondent number 10 to 13 by order dated 1/4/2019. And therefore he is unable to get the death certificate of petitioner number 3. Counsel for the state is directed to seek instructions and file an affidavit regarding the status of petitioner number 3. Post on 13, the affidavit be filed by 12th. क्यों लड़ रहे हैं आप लोग? तो सुने थे हम पहले भी लगता है। क्यों लड़ रहे हैं? What is the matter about? मस्जिद लड़ रहे हैं?
Matter है कि मस्जिद land जो है, having the Ravi has donated that land to the
donation.
and that land has been grabbed by the opposite party.
ये dispute writ petition में solve होगा, ये छूट में होगा।
There's a tribunal, tribunal has been formed.
No,
This is not work property.
It is not a matter of tribunal is when there is a matter of dispute of work का dispute नहीं है। illegal registered हुआ।
तो ये भी कहाँ से ये writ में कैसे decide?
ये हम लोग सर्टिफिकेट दे दिखाएंगे वर्क का जो लैंड है ही नहीं वो आप उसको रजिस्टर कर इशू ये तो उसको लोग डिसाइड कर लेंगे।
ठीक है, देखते हैं, पहले आ जाने दीजिए।
हाँ, उसमें हम लोग खतियान देखेंगे, उसमें प्लॉट नंबर लैंड नंबर है ही और जो
हर
बाकी है
चीज में नहीं डिसाइड हो सकता है। अगर इस तरह का लैंड डिस्प्यूट है तो आपको सूट पे ही जाना है।
because the Waqif who has died, the husband of that Waqif has purchased the land and after the
आप तो ये बता रहे हैं प्रॉपर्टी डिस्प्यूट रिट में नहीं सॉल्व,
इसमें रजिस्ट्रेशन का इशू है। प्रॉपर्टी डिस्प्यूट नहीं, प्रॉपर्टी तो है, रजिस्ट्रेशन रॉन्गली क्या है वो कोर्ट ने
और उसको वेरीफाई नहीं किया एज पर द प्रोविजन ऑफ द
रजिस्ट्रेशन वर्क बोर्ड ने किया है ना,
हाँ
गलत सही जो भी कुछ किया है,
उसमें इसमें तो कुछ नहीं
तो इसका डिस्प्यूट वर्क बोर्ड में नहीं कवर्ड होगा।
वर्क का जो प्रोविजन वायलेशन हो रहा है इसलिए इसको प्रोविजन के हिसाब से पहले इंक्वायरी करना था, फिर गजेट में पब्लिकेशन करना था, देन रजिस्टर्ड करना था। द मैटर इज नॉट related to the government, it is related to the work board. Work board has made the violation of the provision of the work board और wrong registered कर दिया, जिसकी कारण क्या है कि मस्जिद जो है अपोजिट पार्टी अभी हैंडल कर रहे हैं और डिस्प्यूट को रेज नहीं कर रहे। मेरे पार्टी को मैंने कहा कि अलग लोग को डिसाइड होगी उसके बाद रॉन्ग रजिस्ट्रेशन लॉर्डशिप कैन
If it's already registered, then under the new act, it is protected.
रजिस्ट्रेशन का डिस्प्यूट तो पहले से चल रहा है ना, अब न्यू एक्ट से इस केस को कैसे कवर कर देंगे? ऐसा बहस मत करिए कि बवाल हो जाए। We make responsible submissions, right? Work property पर बहुत responsible submissions करने हैं।
For case filing, item 13, contempt civil 591 of 2025.
You have the OP number. Sir, for your time, file compliance report.
You file a compliance report or you have filed a compliance report?
No,
कितना टाइम चाहिए?
for the close.
इन्होंने आपको इंस्ट्रक्शन दिया है कि आप फाइल करेंगे कंप्लायंस रिपोर्ट, ओपी नंबर। Contempt civil 591 of 2025. Counsel for the parties are present. Mr. नाम बताइए।
संतोष कुमार था, एसी टू मिस्टर मालिक प्रसाद।
लिख के दीजिए। लिख के दीजिए। Raised for on instructions from OP number 2.
One.
OP number 1. OP number 1 तो normally state होता है।
इसमें स्टेट OP number 2.
OP number 1. Raised for and is granted time till 11th of June to file a compliance report. Post on 13th in the supplementary cost list.
Item 14, contempt civil 593 of 2025.
It is first time.
First time. कौन फाइल करेगा?
Respondent number 2. Respondent number 2.
Have you received instructions? Wait for time.
We will take instruction and file. That is
Contempt civil 593 of 2025. Counsel for the parties are present. The learned counsel for the state prays for and is granted time till 11th of June to file a compliance based on 13th in supplementary cost.
Appearance. For admission, item 15, WPS 806 of 2014.
WPS 806 of 2014. Nobody appears on behalf of the, are you for the state?
I am for respondent number 9. Recorded.
Nobody appears on behalf of the state. On 14 to 24, also nobody, on behalf of the petitioner. On 14 to 25, also nobody had appeared on behalf of the petitioner. It appears that the petitioner is not interested in pursuing this case. Accordingly, this case is dismissed for non-prosecution.
Item 16, WPS 1295 of 2016.
Cost also I have given 9%.
Yes, sir.
Should I, for the purpose of record, should I give the receipt?
How much was the cost imposed?
10,000. The bank details which they have, sir, given the copy of.
Yes, we have received.
Again, as well. Begin. WPS number 1295 of 26. The council for the parties jointly submit that cost of ₹10,000 in terms of order dated 14/2/25 has been received by the petitioner. अब बहस करते हैं तो cost भी मिल गया अब बहस चलिए.
In this case, the claim of the petitioner is that for quashing of the decision of the third review medical board dated 22/12/2015, that is an extra 6 page 90.
Page 92.
In this case, your worship, B declared fit. The employee is Sri Krishnandan Pratap, and the petitioner hearing is the wife and the son of the Krishnandan Pratap. Your worship, the facts of the case is that the husband of the petitioner number 1 was class 3 employee appointed on 5/3/1982, and he was suffering from grave mental disorder since 2014. Then he applied. He was in treatment. Then he applied for employment, Your worship, as per the scheme of the NCWA, Your worship, and the application was preferred for the appointment of petition number 2 on 17/2014, Your worship. Thereafter, Your worship, the medical prescription and other reports and other tests were conducted of the husband of the petition number 1. Thereafter, Your worship, the first medical board was of the view that the review of the medical report of the CIP should be considered. The first medical report is, Your worship, as 884, Your worship.
Krishnananda Prasad is no more.
No. The ground for compassion about in this case is that this medical unfit on the ground that he is not no more in a condition to work for the respondent, so he applied for the appointment of the compassionate ground for his son.
Who was the employee?
Krishnandan Prasad.
Krishnananda Prasad.
Yes, sir.
When did he apply?
He applied on 18/2/2014.
18/2/2014.
Yes, sir.
Saying that he was medically unfit.
Yes, sir.
And prayed for appointment of his
Son, that is petition number 2.
son. Petition number 2. Amit Kumar Singh.
Yes.
What was the disease?
He was suffering from mental disorder, Your worship. Schizophrenia.
Okay. Then he was declared medically unfit.
No, Your worship. First medical board was constituted and Your worship dated 31/12/2014.
31/12/2014.
And he was and the advice of the medical board was to review with the MRI report and psychiatric opinion at the higher center.
Referred to higher center.
Yes. Then again, the second medical board was constituted on 10/7/2015
By the higher center.
by the respondent, Your worship.
So you did not go for higher center.
No, we went, Your worship.
When did you?
We went, Your worship, in the review itself it said with the report from CIP. They were waiting for the report from the CIP branch at page 87.
Page 87.
Serial number 9, advised for review, Your Worship. Sri Krishnan Prasad, review with report from CIP Ranchi.
Okay. So you were sent for that.
Yes, Your Worship.
Then?
Again, Your Worship, on the third medical board that was considered, that is under challenge.
Second medical board.
Yes, second, Your Worship.
First तो आप first बोले 31.
First was for higher center. Then second, there was a report awaited from the CIP.
First तो आपका 31/12/2014 page number 80.
Yes, sir. First and second is
कौन सा?
10/7/2015.
10/7/15.
In this only the with report from CIP Ranchi. It's paid.
Awaiting report.
And in the third, Your Lordship,
Yes.
they declared me fit.
Report आया?
Lordship, that is my case is paragraph number 12, Lordship. That medical, the decision of the CIP was posted to the office of the respondent on
Just a moment.
23.
Where is the latest report?
That is under challenge, Lordship. That is page
90.
90. Yes, Lordship.
This is dated
It is 22/12/2015.
22/12/15. So you were declared fit.
Yes, sir.
Okay. What is your case?
My case is that, Lordship, the report of the CIP was dispatched on 23/12/2015. That is specific case as paragraph number 12, Lordship.
23/12/15.
15.
So what happened?
Lordship. And then my case is that they have declared me fit on 22/12/2015. The report of the CIP was dispatched on 23/12/2015. There was no consideration of the CIP report.
Just a
Whether
moment. This particular medical board, NHS6, was constituted for what? You were each time you are medically examined. Each time you are medically examined. On 22/12/2015, when you were medically examined, there was nothing. It was you were perfect.
but they were waiting for the report of the
Schizophrenia
CIP.
is not something which is in perpetuity. You can have different mental state, different mental problem from time to time. Earlier they were waiting, and when you were re-examined, you must have applied for your examination again and again, isn't it? Without your application, can there be any examination for medical fitness?
But also by this matter, there was a specific direction to the respondent to reply on this paragraph. Lordship, I ordered it 2/8/22.
Forget about that. You
But-
just tell us.
Yes.
Now bench terms सब change हो गया है, मौसम बदल गया है.
Yes, Lordship.
ठीक है.
But my
इसीलिए
case
आप
is-
हमको मेरी इस query का जवाब दीजिए. When this medical board was constituted on 22/12/2015, at that point of time, was it for the purposes of waiting for the report from the medical board, or it was an independent examination?
Lordship, on the second medical board, they were waiting for the report of the CIP.
Very good.
But-
Maybe that at that
But
point of
after
time.
that, my case is that they have dispatched the report on 23/12/2015. So when they were not expertise on the body that I am mentally fit or not, that's why they referred the matter to the
On
CIP.
this day, you were not found mentally unfit. They did not find it proper to even wait, nor there was any occasion to refer you for treatment. Mental condition, medical condition, it varies from time.
Lordship, in this, the second report, I was advised with a report from CIP Ranchi. It is dated 10/7/2015. Third is 22/12/2015. The third medical review.
When were you examined by CIP? What
The
is the
report
date of
was-
your examination?
The report was dispatched on 23/12/2015.
Where is the report?
That is not provided to us, Lordship. The knowledge is to the petitioner that report was dispatched on 23/12/2015. That's why a reply was needed from the respondent and whether this report has been dispatched or there has been a position of this report and this particular review board has been considered that report or not.
Let me just find it out. Have you responded?
That matter has not been responded.
We are coming to the claim. But you will kindly come to page 21. But you let us see the scheme first.
Page number 21
21.
of the counter.
Counter, yes.
When were you scheduled to retire?
Lordship, he was scheduled to retire in March 2016.
Lordship, 1/4/2016.
Yeah, March 2016. Your date of birth is 4/3/1956.
31st March?
31st March.
31st March.
So he made an application for VRS on 17/2/2014. Just few days before completing 58 years.
That was before 58 years as per the scheme.
That's right.
Now you got to come to one judgment also that it is a normal tendency of the employees to secure employment for the next generation when they are about to reach the age of superannuation. Now, Lordship, kindly see the scheme at page 21 of our counter. 9.4.0 as a Lordship.
Yes.
The employment of one dependent of a worker who is permanently disabled in his place. The disablement of a concerned workman should arise from an injury or disease to be of permanent nature, resulting into loss of employment, and it should be so certified by the coal company concerned. So the three requirement: it should be a permanent nature, resulting into loss of employment, and so certified by the coal company concerned. Now next line also, in case of disablement arising out of general physical debility, so certified by the company, the employee concerned will be eligible for the benefit of this clause if he or she is up to the age of 58 years. So Lordship, this declaration that he is suffering from a permanent disease should be within the age of 58 years. He applied, your Lordship, on 17/2/2014. First medical examination, Lordship, he was not found so disabled. Now second examination, Lordship, can you come to page 25? Lordship, he was examined by a board of 6 persons, your Lordships. Lordship, they found him, they took into consideration review case, they considered it that it is a case of review because first time he was not found medically unfit. Lordship, this is in December 2015, 4 months before the date of superannuation. Case of schizophrenia such that they consider it is fit for job, does not come under clause. Lordship, kindly see ADB, there is, you could not read from CIP, does not come under 9.4.0 of NCWA 4 clause, fit for job. So Lordship, when the coal company concerned finds him fit for job, he cannot claim one.
This medical code is under challenge.
He is challenging the communication of this report. Now your Lordship should take into consideration this issue, and now your Lordship, when the writ was filed, he had already crossed the age of superannuation. Now Lordship, two judgments, if Lordship permits me.
I was within the age of superannuation. The writ was filed on 3/3/2016. I was supposed to retire on 31/3/2016.
The point is that on the very first day, you were found medically fit first time. First time, they say that you were found medically
Therefore, it is a case of review.
Therefore, it's a case
That
of
is on 15 Lordship. The first medical board was on 14, 17 to 31/12/2014.
Yes, 31/12/2014.
Yes, Lordship.
And
Found fit, Lordship.
just a moment. 31/12. Where is that report?
Page number 84, Lordship, of the writ petition. And my relevant is
Just.
85.
There is one column declared unfit, other is declared fit.
And advice
Then
for review.
Advice for review.
3 serial.
Serial number 3. That's right, but you have not been declared unfit.
I have not been declared fit also, Lordship.
Did you work or you
And I was
you
not
stopped
working.
working?
I was not working, Lordship. And I have a
He stopped attending. That was also taken into consideration. This is a tendency, your Lordships. Lordships, one judgment we have annexed in the counter itself. The second judgment. If your Lordship sees page 26 of the counter affidavit.
And ultimately you were found fit.
Yes.
on 22/12. But they have replied to para 12, Lordship.
In reply to Parrot, they say that the stated that petitioner was suffering from schizophrenia and he was examined by the Central Medical Board on various occasions. They declared the petitioner as fit. There is no mention about whether they received the report of the CIP and they have considered that, and then they have, on that basis, the medical review board has declared me fit. There was no point of referring me to the CIP. The first day they could have declared me fit if there was no need to review the or see the report of the CIP. Affidavit dated Lordship 25/2/2025. After the direction of this Honorable Court, they have replied to Para 12 of the petition. That is also
Para
very
5 देखिए.
Yes, sir.
Para 5. Though he was suffering from schizophrenia, he was fit for employment.
That the review board says that.
Therefore, even if you are suffering from some kind of problem, it is for them to decide whether you are fit for employment or you are not fit for employment. They may still agree to take work from you.
But my specific case is that I was not employed and there was loss in employment. No salary. I have received no salary lordship for that period.
If you do not go, that's your problem.
I was not in a condition to go. That's why the medical board has twice referred the matter to the CIP and they have not considered it. This is my case.
This judgment is what?
So the one which will just read out. The issue is once he has crossed the age of superannuation, the benefit cannot be extended. In their lordship, the Honorable Division Bench has taken into consideration the judgment of the Honorable Supreme Court in the case of V. Shivamurthy lordship. Para 7 your lordship, the quoted portion is the lordship's case. In internal page 3, as a lordship said. Lordship, last question. There is a lordship quoted portion I am reading. There are of course safeguards to be taken to ensure the scheme is not misused. One is to ensure that mere medical unfitness to continue in the post is not to be treated as medical invalidation for the purpose of compassionate appointment. A government servant should totally cease to be employable and become a burden on his family to warrant compassionate appointment to a member of his family. Another is barring compassionate appointment to dependents of an employee who seeks voluntary retirement on medical ground on the verge of superannuation. This court observed in Ram Kesh Yadav as follows. But for the conditions, there will be tendency on the part of the employees nearing the age of superannuation to take advantage of the scheme and seek voluntary retirement at the fag end of their service on medical grounds and thereby virtually creating employment by succession. It is not permissible for the court to relax the condition relating to age of the employee. Wherever a cut-off date of or age is prescribed, it is bound to certain such. And here, Lordship, unless there is a case of that he becomes a burden on the family.
And ultimately he was found fit.
He was found fit. That is our case.
You cannot, in his case is that since a report was called from CIP, so you should have waited, and that report was binding on you.
And Lordship, there is
Even
one
in the initial stage also, you did not declare him unfit.
Unfit. And Lordship, even suppose for the worst argument we take, suppose CIP or we would have declared him medically unfit in 2015 December, then also that clause would not have come to his rescue. Because he has to be declared medically unfit prior to attaining age of 58 years. There is a cut-off age mentioned.
And what is the date of the medical report? On what date were you examined by the CIP?
That date is not.
That date you will not know.
Dispatch date.
You will not know your date of examination.
That is not mentioned in the. After the second medical board I was settled.
That date is material date. Because you were scheduled to retire on 31st of March 2016. You attained the age of 58 years on what date?
4th March 2014.
4th March 2014.
3rd March, 4th March 2014.
2014, right? And you filed your application on 18 to 2014.
Yes.
You were examined for the first time on 31/12/2014.
Yes.
By that time, this cut-off date had already expired. So, what was your status on 4/3/2014 or any date prior to that is not on record. Correct?
I have applied lordship, but they were to conduct the medical of the.
Then you should have filed a writ petition. नहीं कर रहे हैं आपका केस फ्रस्ट्रेट करने के लिए.
We have filed the writ petition on 3rd March 2016, lordship. That is before the superannuation of the.
सुपरएन्यूएशन के पहले होने से नहीं होगा ना. 58 years अटेन करने के पहले हो.
The whole condition was not in the control of the petitioner.
Compassionate appointment is actually an exception,
Yes.
not a right.
Still, they have not replied whether they consider or not.
We'll take that. That was in para number.
Para 12 lordship of the writ petition. And we have also applied the attendance sheet lordship from February. From March, he is not taken in.
Which date?
The rejoinder dated 12/7/22 lordship at page 9, page 7 in lordship. Page 7 lordship from February 2014 he was not attending.
Did we apply for leave that you are not well?
I have communicated the
Page
same.
number?
Page 7 in lordship to the rejoinder. Serial number 15.
Rejoinder.
Dated 12/7/22.
Page 7.
Serial number 15, that is month February 2014. Physical attendance is there. From there.
But you did not apply for leave.
I have communicated that I am not well. That's why I applied for the compassionate appointment of my son on 18/2/2014.
About the learned counsels appearing on behalf of the parties. This petition has been filed. Sorry. This petition has been filed for the following reason. The learned counsel may, during the course of argument, is not in dispute that the husband of petitioner number 1 and father of petitioner number 2 was an employee of the respondent's estate, and he was scheduled to retire on 31st of March 2016. It is further not in dispute that pursuant to the scheme for grant of compassionate appointment, clause 9.4.0 under NCWA, the petitioner applied for his examination regarding medical unfitness on 18/2/2014, just a few days of attaining the age of 58 years. Prior to attaining the age of 58 years. However, he was examined by the respondents in first medical board on 31/12/2014, in which he was referred, his case was in which there are altogether 3 columns: declared fit, declared unfit, declared fit, and advised for review. And his name appeared at serial number 3 under the column advised for review with note, inverted comma, with MRI report and psychiatrist opinion at higher center, inverted commas. He submits that he was again examined. He must have applied for examination, right?
Definitely, without examination, we not do.
He again applied for examination, and a report was, second medical report is dated 10/7/2015, and his name again fell under the column advised for review with a note inverted comma with report from CIP action.
Only one thing I may be permitted to mention. Person that is annexure 3, series page 81, on the date on which I went to CIP, that is 2/11/2015, I have enclosed the prescription.
2/11/15?
Yes. Latest medical checkup.
The learned counsel has further submitted that it is further not in dispute that he again applied for examination by medical board, and this time the report is dated 22/12/2015, wherein the petitioner was declared fit. The learned counsel has submitted that on 2 occasions earlier, when the report from CIP was to be considered, on the 3rd occasion, without taking care of the report from CIP, the petitioner has been declared fit. Upon a query by this court, the learned counsel for the petitioner has submitted that he was examined at CIP on 2/11/2015.
And even after the third medical review, I went on 22/2/16 also.
इससे तो कोई मतलब नहीं है. On 2/11/2015, and after he was declared fit on 22/12/2015, he again approached CIP, but neither the report of examination on 2/11/2015 nor the report of examination after he was declared fit has been placed on record. नहीं है ना? लगाए हैं report?
Report version was not given to me, Lordship. Only the prescription is with me, and the report was dispatched to the respondent.
He submits that the report of the CIP was dispatched to the respondent on
23/12/2015.
23/12/2015. And prior to that date, without waiting for the report, the petitioner was declared fit on 22/12/2015.
Even after that, I have went to the CIP and they have said that they have increased the medicine also. They have said to review after 2 months. That means I was not in a condition. Otherwise, they would have declared me fit. There is no money.
आपका बहस सुनने में कोई कमी तो नहीं की है बस. There is a limit you can intervene. The learned counsel has submitted that the report was sent directly to the respondent by CIP, and therefore he is not aware as to what was the result of the report. But the petitioner was, the father of the employee was taking medicine. He submits that the NCWA is a beneficial scheme, and therefore the petitioner number 2 was entitled for compassionate appointment in terms of the scheme, as the petitioner was suffering from schizophrenia and he discontinued attending his work right from February 2014 itself. and by that time he had not attained the age of 58 years. The learned counsel for the respondents has opposed the prayer and has referred to the scheme itself and has submitted that the employment offered on account of disablement of workmen is itself a compassionate appointment, and the fitness of the concerned workman has to be seen prior to he attains the age of 58 years. The learned counsel has submitted that the father of petitioner number 2 was examined on 27/12/2015 and he was examined by a board of not less than 6 persons and was found fit for job. The report has been annexed along with the counter affidavit. Yes, he has also submitted that it is the satisfaction of the concerned whole company as to whether they would like to take work from the ex-employee or not. It has also been submitted that as per the petitioner himself, he was examined on 2/11/2015 by CIP, and by that time he was already crossed the age of 58 years and was on the verge of retirement. That's it.
There are 2 points. One is annexure B, we kindly be seen at page 20. This is the guidelines for the disposal of the application under 9.4.3. Herein the disease, any mental disorder, schizophrenia is not the disease for which an employee can be declared unfit. And the list of the diseases have been mentioned.
Annexure B.
Annexure B, page 20. So he is
The
not under
learned
this
counsel
list.
has also referred to annexure B to the counter affidavit to submit that it contains a list of disability which could be the reason for consideration of the case, and schizophrenia is not mentioned in the list, and therefore otherwise also the petitioner was not entitled for relief of clause 4.9.4.0.
And the one more
9.4.0.
Yes. 9.4.3 is medical examining, medical and fitness scheme.
9.4.3
of NCD.
9.4.0 employment to one dependent of the workman is cognizant. Anything else?
And my lord, he worked till the age of superannuation. So even otherwise, because he has worked,
He has not worked. He says that I did not get
That is the certificate given by the senior manager of the.
He has not attended.
There are
The learned counsel has relied upon the judgment passed by this court in APA number 223 of 2017 and has submitted that in the same judgment the scheme has been considered and judgment passed by the Honorable Supreme Court reported in bracket 2008 bracket close 13 SCC 730 has also been considered, and it has been held that the appointment is an exception to the general rule of appointment, and there would be a tendency on the part of employee nearing the age of superannuation to take advantage of the scheme and seek voluntary retirement at the back end so as to secure employment for their successor. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, admittedly the father of the petitioner number 2 had applied for his examination regarding medical fitness just little more than 1 month prior to had applied on 18 to 2014, and he was to attain the age of 58 years on 58 years on
4/3/2014.
on 4/3/2014. Less than a month. On 4/3/2014. While the petitioner was examined on the first time, that is on 31/12/2014, he was neither declared fit nor declared unfit, but he was to be examined by higher center. On the second occasion, when the petitioner applied, he was examined on 10/7/2015, and it was indicated that report from higher center would be awaited. However, admittedly, the petitioner was examined by CIP on 2/11/2015 itself, meaning thereby after the first medical board on 31/12/2014, the petitioner was not examined by CIP.
But after the first medical board, I was sent to the higher center. Then I went to the fellow below, CMC fellow. There are reports of CMC fellow. The second medical review, they were sent for report from CIP. Then I went to CIP. Higher center, I went to CMC.
The petitioner was examined, the father of the petitioner number 2 was examined on 2/11/2015, and neither the petition and the said report is not placed on record. Further, it is the case of the petitioner that the report was dispatched by CIP to the respondent on 23/12/2015. However, prior to even dispatch of the said report, the father of the petitioner number 2 was examined on 22/12/2015, and he was declared fit. This court is of the considered view that there is no declaration of unfitness of the petitioner, father of the petitioner number 2, on 31/12/2014 or even on 10/7/2015, and ultimately on 22/12/2015 he was declared fit. The fact remains that the father of the petitioner had applied for his examination of medical fitness just a few days prior to attaining the age of 58 years. And it further appears from the rejoinder that he was not attending office and remained absent, but nothing has been placed on record as to whether he ever applied for any leave on medical ground. Considering the totality of facts and circumstances, this court is of the considered view that ultimately it is the opinion of the employer as to whether the work is to be taken from the ex-employee or not, from the employee or not, and at no point of time the respondent ever asks the father of the petitioner number 2 not to attend duties. He voluntarily stopped coming for duty from February 2014. The law is well settled that the claim of compassionate appointment can never be a matter of right. It is an exception, and considering the totality of facts and circumstances, particularly the fact that the father of the petitioner number 2 was never declared medically unfit on 3 dates of examination, that is on 31/12/2014, 10/7/2015 and 22/12/2015, when he was ultimately declared fit for performance of duty. This court is not inclined to grant the relief as prayed for in the state petition. It is hereby dismissed. यहाँ पे कोई examination है ना? Examination, medical witness examination, petitioner का नहीं है. Father of petitioner number 2.
Item 70, WPS 233 of 2018.
Let this one come next week, possibly.
Compassionate direction of the files also commentary and exit the date of birth of
Date of birth of the I will find
father.
Date of birth of the father of the petitioner.
Petitioner bringing the award on record and also bringing on record the date of birth of the petitioner, whether he qualified for the grant of compassionate appointment.
As per this, he qualifies. You want to respond to this?
He'll file a response to
You
this.
file a formal response, whatever it is, because at times they may refer to some document, some statement.
Ladyship, even the award that they have brought on record, continuously they have been in the entire petition, they have been speaking about reference case number 50 of 91, by which the services of the father of the petitioner was regularized, and the award of some other case 79 of something has been brought on record. That may kindly be seen.
We'll dismiss it on this ground. We'll dismiss it on this ground. It means that he doesn't have the award, whatever he is referring to in the decree.
This is the reference case number 76 of 1985, and in this it has nowhere the regularization has been done. He says that a reference case was filed, that was reference case number 50 of 91 for the regularization of the workman.
He was asked to file the award.
Yes, that order may kindly be seen, Leadership. It happened.
23, 22. Very good. We dismiss it. What's the big deal about it?
And this is
Just pass over for it. They have not complied with the order. We don't bother about it. Why should we? Call him, right? And tell him. सेकेंड हाफ 5 बजे तक भी तो हो जाएगा ना. सेकेंड हाफ में बुलाइए. आज ही करेंगे. एडजर्न नहीं करेंगे इसको.
Item 18, Civil Review 40 of 2022.
What is it? Client has taken NOC. Civil Review number 40 of 2020. Counsel for the petitioner, MS number Omia Anusha submits that the petitioner has taken no objection from the petitioner, from the council. However, no fresh wakalatnama has been filed in this case. Accordingly, this review petition is dismissed for non-prosecution. You have to put your signature, please put your signature.
Item 19, Contempt Bill 069 of 2023.
Yes. What is the number of LP?
The LP has now been registered in petition. It is LP 235 of 2025. 2025.
Contempt case civil number 669 of 2025. Counsel for the petitioner is present. Nobody appears on behalf of the opposite. Counsel for the opposite party is also present. It is reported that LP number 235 of 2025 has been filed against order dated 22/11/22 passing WPS number 800 of 2009. When should I post this matter?
After vacation.
जरा तक कर।
After vacation 2 weeks का time दिया जाएगा.
Let this matter be posted on 1st of August or after disposal of the posted LPA, whichever is earlier.
Applies to that.
Item 20, WPC 3265 of 2023.
In this case, I have filed a IE number 2982/2025 for amendment in clear portion.
Not amendment. I told you I will not allow amendment to file a fresh bill. It will change the nature of the entire bill.
Same,
Same.
relating to the division of land. See,
Acquisition of land under different acts, different provisions. Now, what amendment are you seeking? What is the nature of amendment?
maybe relating to the passing of the notification of the
What amendment are you
public
seeking?
notification. Maybe 9 months.
Sorry?
into
What amendment are you seeking?
amendment relating to it's a 10 and 11.
First, let us see what is the amendment.
Notification of acquisition of the land. Same bill, gram.
Now you want this National Highway Act does not apply to regulators. Earlier you were asking that this 2013 Act does not apply to regulators.
फोर लेन वहाँ बन गया है, रोड चालू हो गया।
So the last step is the lordship has directed us to file a supplementary counter affidavit.
Four
That
lane
has been specifically
रोड बन
filed.
गया।
Yes.
My supplementary affidavit will be seen by the type of file pursuant to last order.
What have you stated?
Well, that thing has specifically been brought on record that due to mistake matters instead of land acquisition, National Highway Authority Act, it was mentioned Land Acquisition Act. That has been specifically mentioned in this. Para 4 onwards.
Dated, what is the national dated?
It was filed on 21 to 2020.
Para 4.
Para 4.
And provided the statement of the lead petition.
It has been acquired under National Highway Authority Act and not under this 2013 Act. And what is his main relief?
His main relief was with respect to that as it has been acquired under Land Acquisition Act. So this everything goes because the
the act has not been extended by the governor to that particular area. This was particularly.
We will not, it will completely change the nature of the. It will completely change. You file a fresh writ petition. We can't do anything about it. Because now you are, first you say that this 2013 Act is not. Now you want an amendment that 1956 Act is not.
That the counter APT filing, the counter APT I will do.
That's right. So you file a fresh writ.
The National Highway Act. The
You file a fresh
notification of the.
You see, entire writ petition is based on the fact that the accusation is under 2013 Act. All the pleadings and the counter affidavit, etc., is based on that. Now you want that the writ petition should be amended, and now it should be declared that 1956 Act is not.
Also, the notification of the government is also.
No, you file a fresh writ petition. The entire texture of the writ petition is one. We will not permit you to change the writ petition to such an extent. You straight away shift to another act. We will give you liberty to file another writ petition, but in this writ petition it cannot be filed.
But Consequor is only I have converted my writ petition.
Converted means who will convert?
Converted the para is my writ petition also.
Because you see the entire texture of the writ petition is different. Your entire texture is that this act is not applicable. You are referring to various provisions of the Act of 2013.
Lord, may kindly see
clarification, my lord, sir.
The para 45 of my rejoinder allows.
Rejoinder will not make a case. Rejoinder does not make up a case. You have to make out a case from the writ.
Respondent is silent of the respect to administration and control of the city being judged.
See, you want a particular act to be declared not applicable in the writ petition.
Already
Now,
not applicable. That why I am wanting to ask
now
the
you
public
want.
notification.
No, there are many nuances that there are different acts. It's not one and the same. We will not change the nature of the writ petition to such an extent. No. This we will not permit.
And the fact that the acquisition has been made under NH Act was also known to him. That would also become clear from the arbitration order where he has filed. May kindly see the counter affidavit dated 29/1/2025, filed on behalf of respondent number 125. Counter affidavit dated 29/1/2025.
Counter affidavit dated
29/1/2025. Filed on behalf of respondent number 125.
Respond number 7.
And then 1 to 5 comments.
Yes. 3125.
My lords, in that case, my lords, kindly see page 8, my lords. Annexure E.
आप डेट फिर से बताएंगे?
29/1/2025.
29/1. तो rejoinder है
It has come on record, my lords, on 31/1/2025.
21/1.
31/1.
31. Yes.
Once we kindly see annexure E, page 8, my lords.
Yes.
This arbitration proceeding was, my lords, done by the petitioner himself. Was petitioner was there, my lords. Rayat Gram Panchayat Bureau Block.
Yes.
They have filed a case आदेश अभिलेख उपस्थापित अभिलेख में उपलब्ध रैयतगंज ग्राम पंचायत बेड़ो की ओर से श्री सुवैनसो मुखिया सुवैनसो की ओर से NHAI की ओर से परियोजना निदेशक प्रोजेक्ट डायरेक्टर PIU एवं अन्य अधिवक्ता उपस्थित। रैयत ग्राम पंचायत बेड़ो का प्रति डी को लेकर आपत्ति आवेदक जिला भूअर्जन पदाधिकारी
रेफरेंस ही है सीधे NHAI
पूरा NHAI का
देखा जाए पार्ट 9 में पेज 9 में देखा जाए,
क्या देखें पेज
3 में देखा जाए इसका दर अधिकतर दर
अरे भाई
अधिकतर
डेट
पाया
उससे
गया
तय
इनको
होता है, भाई डेट उससे तय होता है, इससे क्या मतलब?
लैंड एक्विजिशन एक्ट 2013 के तहत सब कुछ किया गया है।
2013 के तहत इस तरह से आर्बिट्रल अवार्ड बनता है क्या? 2013 में आर्बिट्रल अवार्ड नहीं बनता।
लिखा हुआ है इसमें वही निर्धारित क्षेत्र
नहीं
पढ़ देते हैं, उसी को पढ़ रहे हैं। पारा पेज 11 में भी लिखा हुआ है,
क्या लिखा हुआ?
लेख में उपलब्ध कार्य तो परियोजना की महत्ता है NHAI
आप
नेशनल ऑथोरिटी ऑफ इंडिया, ये तो
पेज नंबर 14 पढ़िए, पेज नंबर 14 पढ़िए, पेज नंबर 14 बॉटम में पढ़िए। तो
पहले पेज नंबर 11 पढ़ते थे, उसके बाद पढ़ देंगे।
जो बोल रहे हैं पहले पढ़िए, आपका वो भी पढ़ेंगे। पेज नंबर 14 पढ़िए, बॉटम अभिलेख में उपस्थापित पढ़िए, अभिलेख में हाँ पढ़िए।
उपलब्ध कागजात परियोजना की महत्ता नेशनल हाईवे अथॉरिटी ऑफ इंडिया एक्ट 1950 की धारा 3G के धारा 7 में वर्णित तथ्यों में ध्यान में रखते हुए लैंड एक्विजिशन एक्ट 2013 एवं झारखंड नियमावली 2015
समझ में आया?
NHAI नेशनल अथॉरिटी ऑफ इंडिया तो है नहीं कोई चीज, तो
ऐसा
दूसरी
कुछ
एडमिनिस्ट्रेशन
नहीं है।
कंट्रोल है, इसमें इसके तहत हो ही नहीं सकता 3G के तहत।
तो फिर आप क्यों
नेशनल
amendment
हाईवे
करते हैं?
एक्ट के तहत होगा, नेशनल हाईवे अथॉरिटी ऑफ इंडिया के तहत नहीं होगा। इसमें लिखा हुआ है
तो फिर आप amendment किस लिए फाइल करते हैं?
नेशनल हाईवे अथॉरिटी ऑफ इंडिया लिखा हुआ है।
नहीं NHAI
नेशनल हाईवे
हाईवे
अथॉरिटी ऑफ इंडिया, नेशनल हाईवे एक्ट फॉर द एक्विजिशन ऑफ लैंड, नॉट फॉर द नेशनल हाईवे अथॉरिटी ऑफ इंडिया।
ठीक है, समझ
दैट इज
नहीं, ये अमेंडमेंट हम लोग नहीं अलाउ कर सकते हैं बिकॉज उसका कंटूर्स ही अलग है, वो प्रोविजन अलग है। अगर आपको लगता है कि वो प्रोविजन नहीं अप्लाई हुआ है स्टेट ऑफ झारखंड में, तो उसके लिए आपको अलग से यू विल हैव टू टेक स्टेप्स इन अकॉर्डेंस विद लॉ, क्योंकि ये जो अवार्ड है ना NHAI का एक्ट का, देयर इज अ डिफरेंट प्रोविजन फॉर चैलेंजिंग दीज अवार्ड्स, उसके बारे में हम कुछ नहीं बोलेंगे। बट दिस अमेंडमेंट आई विल नॉट अलाउ, दिस इज एब्सोल्युटली चेंजिंग। आपको पिछली बार भी बोले थे अमेंडमेंट फाइल करेंगे तो हम आपको अलाउ नहीं करेंगे। आपको नहीं याद होगा लेकिन हमको याद है। ये सब चीज़ हम भूलते नहीं है, जब तक केस क्लोज नहीं हो जाता है एक लाइन हम नहीं भूलते। I will not allow this anymore. If you want liberty, I give you liberty. Liberty चाहिए?
लिबर्टी
ये सुप्रीम कोर्ट का ऑर्डर जरा प्लेस करेंगे। The same villages, they filed a petition in the Supreme Court directly.
Yes.
Yes. And then
first to file the PAN, this honorable court, thereafter after withdrawal with the Supreme Court.
no, you just tell us what all are the proceedings that you have filed. One is Pero round.
Yes, yes.
Who is he?
The village pradhan.
Pero Oran, village pradhan. He filed writ petition. He filed SLP against the High Court of Jharkhand. Yes. Order का तो यही दिख रहा है. Pero Orao versus the High Court of Jharkhand at times.
Order, he not done properly. Then they have to move to the Supreme.
So you made High Court as a party. No, let me understand. भाई आखिर ये जो ऑर्डर हमारे रिकॉर्ड में लगा हुआ है, तो आप बताएंगे ना ये किस सर्कमस्टांसेस में ये गया था मैटर? आप रिकॉर्ड देखिए यहाँ दो सुप्रीम कोर्ट का ऑर्डर लगा हुआ है, उसको बिना ऑर्डर को रिकॉर्ड किए और उसके बारे में बिना लिखे तो हम आपका ऑर्डर नहीं कर पाएंगे ना, फिर ऑर्डर मेरा डिफेक्टिव हो जाएगा, क्योंकि ये giving liberty to the petitioner to move appropriate application before the High Court either for early listing of the case or for withdrawal of any other relief. इसमें withdrawal का भी relief आपको मिला होगा सुप्रीम कोर्ट से, क्या withdraw भी कर सकते हैं. उसके बाद एक ये दूसरा ऑर्डर है, तो इसका बैकग्राउंड नहीं बताएंगे तो कैसे बताइए ये किस प्रोसीडिंग के अगेंस्ट में गए? Yes. बताइए रिट पिटीशन सिविल सुप्रीम कोर्ट में डायरेक्टली रिट पिटीशन फाइल थी, किस लिए किए थे और उसमें हाई कोर्ट को पार्टी बना दिया?
यहाँ हाई कोर्ट के फाइल थे नेक्स्ट वन
Page 39. तो withdrawal का order. फिर you going to file fresh petition with better particulars. Correct? उसके बाद आपका सुप्रीम कोर्ट का ऑर्डर का कौन सा डेट है? 10/4/23. अच्छा, पहले 10/4/23 में पेरो और राव के केस में ये ऑर्डर हुआ. ये ऑर्डर को एक्सप्लेन करिए. पेरो हो रहा हूँ, ये ऑर्डर कैसे आया? ये सुप्रीम कोर्ट का ये ऑर्डर विद पिटीशन सिविल नंबर 369 ऑफ 2020. सॉरी,
रिकॉर्ड इज नो.
आप देख लीजिए, सेकंड हाफ में आ जाइए. आइए तो हम इस तरह से नहीं अलाउ कर सकते ना. आई एम नॉट इंक्लाइंड. पूरा चेंज हो जाएगा, पूरा रिट पिटीशन का टेक्सचर चेंज हो जाएगा.
पास एनी ऑर्डर.
Any order means you are not aware.
How can you know it?
सुप्रीम कोर्ट आप गए, आपको पता नहीं है. हाई कोर्ट को पार्टी बनाकर.
Pero now is petition number 2.
Not allowed the IA on the own.
Sorry.
Not going to allow the
You
IA.
see that I want to know from you. I want to know from you that for what relief and for what purpose Pero Rao, who is petitioner number 2 in this case, went to the Honorable Supreme Court. And what was the occasion of the Honorable Supreme Court to even make an observation that he can withdraw the case? अच्छा, कोई बात नहीं. आपको नहीं पता है ना, हम रिकॉर्ड देख के सेकेंड हाफ में आपको नहीं पता है, हम यही लिखाएंगे कि आपको नहीं पता. सॉरी, नॉट रेडी तो टाइम मान लिए. ये मत बोलिए दैट यू कैन पास एनी ऑर्डर. जब आप ऐसा बोलेंगे तो हम भी यही लिखाएंगे दैट यू हैव सेड दैट आई कैन पास एनी ऑर्डर, यू आर नॉट अवेयर. आई एम पुटिंग यू वेरी पर्टिनेंट क्वेश्चन. There are 2 orders of the Supreme Court on record. So you have to tell me and under what circumstances, what was the occasion you went to Supreme Court. एक में High Court अपने एक party हो. It's a serious matter. When High Court has become a party in a proceeding, isn't it? Serious matter है ना?
No.
Party का नाम ही है High Court. Pero Rao versus High Court of Jharkhand. यही पार्टी का नाम है. देखिए, अगर हम गलत देख रहे हैं तो आप जरा देख के बताइए. दिखाइए. Pero Rao versus High Court of Jharkhand है क्या?
Possibly, man, he went for early hearing of this.
I do not know. So he has to explain it to me as to how the High Court becomes a party in a proceeding. भाई क्या इतना serious था? क्या High Court का building acquisition पर कुछ allegation है? हो सकता है. जब पूरे झारखंड में नहीं apply कर सकता है तो फिर High Court का building भी गलत बन गया.
Not only 14 district, 13 district.
Also, similarly, man, in another case where judgment was reserved for a few years, High Court was made a party members in that case, and it was filed before Honorable Supreme Court under Article 52, so that judgment may be pronounced in that particular case. So you might have also have gone saying that Honorable High Court is not deciding the matter, so give a direction.
I do not know. It is for him to explain, no?
That interferes. That's why he made Honorable High Court part through the registrar and the party members. Alleging that the case is not being decided in the High Court, so the direction will be given.
हम नहीं जानते. इन्हीं को बताना.
What was the petition before Supreme Court? Should be produced.
इनको लिबर्टी भी नहीं चाहिए. इसका मतलब सोच रहे हैं कि भाई हम इस ऑर्डर को चैलेंज करेंगे. अगर इस ऑर्डर को चैलेंज करने के बारे में सोच रहे हैं तो सारा बैकग्राउंड लिखा के ना हम ऑर्डर पास करेंगे.
और ऐसे भी इंफ्रास्ट्रक्चर हो गया माइनर रोड बन गया 4 लेन.
नहीं इंफ्रास्ट्रक्चर नहीं होता है. केस ऐसे इंफ्रास्ट्रक्चर नहीं होता. When the applicability of the act is under challenge, it does not become infractuous.
Yes, challenge Land Acquisition Act 2013, now it has come that it is under NH Act. That has not anywhere been challenged in the writ petition.
Therefore, I am saying that it's a different context altogether. So we will not allow the amendment.
एरिया में भी फायर होता है पब्लिक पर्पस के लिए. अब इनका कहना कुछ प्रोसेस फॉलो नहीं हुआ.
आप देख लीजिए. आप बताइए. आप फिर एफिडेविट फाइल कर दीजिए. हम आपको डायरेक्शन दे देंगे. नहीं करिएगा तो हम लिख देंगे कि आपने इसका कंप्लायंस नहीं किया. इसका एफिडेविट फाइल कर. WPC number 3265 of 2023. The records of this case reveal that the writ petition was filed seeking a declaration that the Land Acquisition Act 2013 does not apply to scheduled area of the state of Jharkhand. Now, a petition seeking amendment to the writ petition has been filed. So as to amend the writ petition and seek a declaration that National Highway Act 1956 does not apply to scheduled area. The learned counsel for the respondent has submitted that the petitioner very well knew that acquisition of land in the present case is governed by National Highway Act 1956. Still, the relief was sought that Land Acquisition Act 2013 is not applicable. If the amendment is allowed, the entire nature of the petition will change. The Land Acquisition Act 2013 and National Highway Authority Act 1956 are two different statutes altogether. The records of the case further reveal that the petitioner number 2 namely Pero Orang had approached the Honorable Supreme Court in writ petition within bracket civil bracket clause number 369 of 2023 whose final order dated 10/4/23 has been placed on record. But during the course of hearing, the counsel for the petitioner is not able to explain as to under what context and for what purpose the said petition was filed before Honorable Supreme Court. In the said petition, liberty was also given to the petitioner to move application before the High Court either for early listing of the case or for withdrawal or for any other. Counsel for the petitioner prays for and is granted time till 11th of June to explain the position by filing an affidavit. It is also important to note that an order dated 13/9/2024 has been placed on record, which has been passed by Honorable Supreme Court in WPS Civil number 549 of 2024, wherein the High Court has been requested to take up the writ petition pending before this court as expeditiously as possible, and the same has been communicated by the Honorable Supreme Court, and in the office note prepared by Joint Registrar Judicial of this court, it appears that the connected writ petition is the present writ petition being 3265 of 2023. Considering the fact that the petitioner has filed a petition seeking amendment of the writ petition, which in the opinion of this court may change the very foundation of the writ petition, inasmuch as in the present writ petition a prayer has been made that the Act of 2013 is not applicable, and through the amendment a totally different prayer is sought to be made by seeking a relief that the National Highway Act 1956 is not applicable. However, still the petitioner is directed to file the affidavit with regard to the aforesaid order, that is order dated 10/4/2023, passed in writ petition civil number 369 of 2020. 11 तारीख तक कर देंगे. Counsel for the petitioner has submitted that the required affidavit will be filed by 11th of June, post on 13th.
There was a possible matter for one team also, but before that it is disposed of also serial number 1 supplementary. My
Serial
appearance on behalf of the state department. Serial 1 supplementary.
क्या इसको सब क्या
My appearance.
ऐसे नहीं रिकॉर्ड कर सकते.
Morning was 5 was there. It was possible for one.
इनके appearance आप अपना केस नंबर वाइज ठीक है. It is covered. आपका सबमिशन है. क्योंकि सबमिशन इसमें स्टेट आप रेस्पोंडेंट का ये लिखाया है. It's a covered.
Yes.
Item 21, Contention Bill 337 of 2024.
Last revision direction was not for serving notice to police party 2 and 3 by the consent list.
I am appealing on behalf of respondent number 2 and 3. In the writ petition, there was an order that the GB has to take a decision with regard to his representation. He has filed his representation, but due to decision order of this Honorable High Court, GB is not functional since 10th of October, 5th of October 2023. Petition number 6526/2022. So,
where is your show cause? You are appearing on behalf of whom?
I am appealing on behalf of respondent number 2 and 3. I filed my wakalat.
Your file. Where is your show cause?
No, show cause we cannot take a decision because there is no GB at it, and GB has to take a decision.
That
It's an
has to
affiliated
come.
college.
That has to come on affidavit.
It's not taking in 2 weeks time. We will filing detailed show cause.
Why have you taken this so lightly? We
just
sent
not-
you notice through police station, and you have not even prepared your affidavit. You are making oral submissions.
Yesterday only we got received instruction. Only also 1 week time we will be filing. Respondent number 3 also have been recently appointed. So the college is being run only by the principal and the university representative. There is no GB since 5th of October 2020.
What was the nature of order?
So prayer was for payment of arrears.
Payment of?
Payment of arrears. Arrears was paid.
You are taking your own salary. आपको पैसा मिल रहा है? बिना जीबी के आपको पैसा मिल रहा है कि नहीं मिल रहा? वो भी बंद हो जाना चाहिए. जीबी नहीं है, कौन साइन करेगा चेक? There is nobody to sign the check without the authority of GB. पैसा मिल रहा है कि नहीं मिल रहा?
As of now, university is only taking care of the college through university representatives and the principal. The college is being done.
So why for the petitioner you will not take a decision?
We will take a decision, but the only problem is that it has been written that GB has to take a decision, and GB needs a quorum. At least out of 7, 5 people needs to be there. It was placed before the GB Milord on 12th of September.
So you
But-
file a modification of this order. That who will take a decision? GB नहीं रहेगा तो फिर ताला तो नहीं लग जाएगा हाथ में. Who will take a decision?
Milord, in that case, Milord, the university representative, who is also in charge of as the secretary, he is functioning as the secretary of the government. Then
So
he can only take a decision.
therefore, you have to file a modification in WPS number 1280. आप modification के लिए फाइल करेंगे और you file an affidavit. देखिए कंटेंट में तो हम नहीं मॉडिफाई कर पाएंगे ना ऑर्डर. Secondly, if the university representative is now de facto DB,
In a way, we will say
de facto, right? Then he has to take a decision. Then the order has to be complied. He is only concerned with the compliance of the order. Whosoever
Not
complies.
to say that he is de facto GP. He is only just concerned that for conducting the regular day-to-day affair of the college. He is just taking care. It's just temporary arrangement.
GP कब से नहीं है?
5 October 2023. From that only, this honorable court has directed the university to seize the power of the government. And even that GP had tenure has expired without, and no new GP has been found because of that order.
The petition was filed before the 15th of university, 24/7/2023. So there was a specific direction that on that particular date.
नहीं आप देखिए ये कह रहा है कि GP नहीं है is not enough. Somebody has to take a decision. आपके यहाँ जो भी स्टॉप गैप अरेंजमेंट होगा यूनिवर्सिटी का सेक्रेटरी होगा जो रिकॉर्ड देख के ऑर्डर पास करना है इसमें क्या हियरिंग करना है आप रिट पिटीशन में कुछ मॉडिफिकेशन फाइल कर दीजिए हम ऑर्डर मांगते हैं आप सर्व कर ले लीजिएगा they will ask somebody else to pass the order यही होगा ना because this order is not capable of compliance therefore you file a modification in the read petition and then I will modify the order accordingly. Correct?
Yes.
कब बैठना है 13 to post on 13 अपना appearance दे देंगे
Item 22, Content Civil 1087 of 2024.
Compliance with the earlier order suppose.
What happened? Compliance?
But we have written email to the concerned institution that we have not received any instruction.
With respect to providing the address of all India University, he has filed an affidavit on the date 28th of August.
No response to this?
I have mentioned the email also. Whatever directly to mention.
कहाँ है email? Okay. Email address?
वही 29 वाला एफिडेविट में दिया हुआ
Annexure A में?
एनेक्सर ए
Affidavit में बताइए कहाँ affidavit? पैरा नंबर, पेज नंबर?
Page 8.
This is under the central government. नहीं पता.
That could not be changed.
Business.
आउट ऑफ वे हम एक चीज़ से पॉइंट आउट करना चाहते हैं मैं हमको व्हाट्सएप पे एक मैसेज आया है जिसमें दिस जनरल क्या है डिस्ट्रिक्ट जनरल ब्रांच और कोर्ट has sent a letter to the on the address of this university members for regarding the verification of my certificate. That is with me, members. It is All India Council of Open Education, Kadam Tala, opposite Azad Hind Pathgar, Lakshmi Aviation, Jalpaiguri, West Bengal.
तो इसको तो आप इस कम्युनिकेशन को तो आप इसमें एफिडेविट में लगाएंगे
नहीं वही आप ये मेरे व्हाट्सएप पे जस्ट कम्युनिकेट हुआ है हमको जो कि इन्हीं के द्वारा भेजा गया था उनके एड्रेस पर रिगार्डिंग वेरिफिकेशन ऑफ माय सर्टिफिकेट सो इट गोज टू सजेस्ट कि किसी
आप इसको एफिडेविट में लगा दीजिए तब हम भेज देंगे तब हम इनसे पूछेंगे इनके पास एड्रेस है ना? चिट्ठी आपने भेजा था
जो का सर्टिफिकेट में ईमेल लिखा हुआ है वही ईमेल में हम लोग क्वेरी किए इंफॉर्मेशन मांगी।
ईमेल में नहीं आपने
नहीं, it is of the dated 3/7/2020.
3/7/2020 को आपने लेटर लिखा था
13/7/20 को उप समाहर्ता सप्रभारी जिला सामान्य शाखा को
Content Civil 1087 of 2020. The learned counsel for the opposite party has referred to affidavit dated 28/4/2025 mentioning that the opposite party had sent email to All India Council for Open Education at their email ID info at aicoe.in and requested to provide the complete address of the head office of All India Council for Open Education as well as the name of the authority/office bearer. But he submits that no response has been received. The learned councils submits that under such circumstances, they are not in a position to give the address of All India Council for Open Education and also the name of their authorities. Counsel for the petitioner in response has submitted that has prayed for some time to respond to the showcase. एक हफ्ता में हो जाएगा? Post on 13 June. The affidavit be filed by 11th